I'll work on background. Let me make sure I have started everything. It's been a couple of weeks. I've kind of out of practice. That one's just not starting. Oregano, the program that does the faces in the corner is not even opening for some reason. I don't know why. It's like it's trying to start, but it hasn't yet. So, me. Just for fun. Oh wait, no, not that. I don't want that. How about that?
Skip the delivery phase and grab these 0 to 5 grams of net
Sorry
carbs
guys, let me get this.
straight from your freezer. Hero's Everything Bagel is my morning go-to. It has 17
It did
grams
start?
of protein and a flavor that satisfies my cravings. The white bread, it's 0 grams of net carbs per slice, and it toasts up crispy while staying soft on the inside. And the tortillas are just one.
Why aren't you showing up here? Let's see here. Audio. Hold on, guys. I'll get it. Ah, there we go.
But that gives little or no effect to future
Can you hear it?
contingent life leasehold and the many expired interests, including patents, and places an open for business sign on property taken from Americans, all contrary to why Title III was enacted.
One sec. Let me get one more.
The cruise lines acted in concert with Cuba and paid state security forces $130 million to make $1 billion without seeking our authorization. They relied on the suspension of the private right of action, but now would have this case be all about Cuban property law. But the Claims Commission conclusively resolved those issues
Morning.
and gave courts all the guidance needed regarding the claim and confiscated property at issue in Title III cases. I welcome the court's questions.
What exactly is the property here that has been confiscated?
Thank you. I
The
appreciate
interests that were taken from us are the equivalent of a leasehold and comprised the docks, the land, the rights to operate those, the concession, and machinery. Confiscated property, though, in terms of the anti-trafficking prohibition, is the docks themselves.
I thought your claim had to do with the usufruct rights that you had.
That's correct. The claim reflects the particular interests that were taken from us. Those include 2 usufructs, the first of which gave rights over an area that allowed us to construct the works and operate them. That's plenary control. As the 11th Circuit indicated, the usufruct is for all uses and for all fruits. And the other usufruct was in relation to the areas between streets on the land that was granted later.
Usufruct is a great word that I don't hear very
plenary
often.
commercial control in relation to that.
So it seems as though
Use
you
of the
are,
fruit. That is a civil law
treating
term.
the usufruct interest that you have almost as a actual ownership of the property itself. So
I wouldn't say that, no. We're treating it as
Thank you,
essentially
guys.
ownership of a
Thank you.
leasehold, a set of
And thank you, Larry.
interests related to the facilities. The facilities themselves are what was seized and are set off limits, but that's the underlying property. We don't own the docks other than in the sense of having held a leasehold interest in relation to those.
But you normally don't think of someone as confiscating a lease or a leasehold.
That's right. That's exactly our principal argument, is that we
Petitioner
don't
is
naturally think
Exxon.
of trafficking or confiscating necessarily being the interests, that it's the underlying property that is the sort of subject of the anti-trafficking prohibition, and then the taken interests are reflected in the claim.
Counsel, isn't the other answer to Justice Thomas and the concerns about what is the nature of this property taken care of by the statute itself? Because it seems to me that property is a defined term here, and that the statute
Petitioner,
itself
I have the cases
includes
backwards.
the kinds of interests that you're talking about.
Petitioner is
not
American.
just real property, but also things like the leasehold interest you're describing.
Absolutely. Leasehold and any other interests are included in the statutory definition. And I would say that the property definition is so broad that it includes both the underlying things, the res, and the interests themselves. And it has two parts. The first part is, as you say, the sort of real, mixed, and personal property, the things,
Yep.
underlying things. And then the second part is the interests. And that can be present, future, contingent.
And I guess my point is that we have defined terms in this statute that tell us what Congress intended when they said you are trafficking in confiscated property. The words trafficking, confiscated property, all of those things are in the statute. So it's a little confusing how the 11th Circuit got to essentially redefine what it means to be trafficking in confiscated property in light of this statute.
That's absolutely true, particularly if we focus on the word confiscated. Confiscated has the effect of indicating that stolen property remains stolen until three things happen. It's the claim, the underlying claim is settled by the international claims process, the property is returned, or particularly adequate compensation is paid.
Well, Mr. Klingler, whatever the definition of property is, I mean, you can't sue for property that you're unconnected to, right? You can't just say,
Their lease ended in 2004.
seized a piece of property across the street someplace, and I saw it, I didn't have anything to do with it, I think I'll go bring a lawsuit about it.
No.
You can't do that.
That's absolutely right.
So what the statute is saying is that the person can sue for property that has been confiscated from that person, correct? And once you read the statute like that, it
Tap your
seems
screens,
as though that
everybody.
the
Let's get some
property that was confiscated from that
people in
person
here.
is here not the docks. The docks is the physical thing, but the property that the person had was just an interest in that physical thing. It was, a stick in the bundle, whatever you want to call it, but the property that the person
Yes, Eddie.
had was a concession.
If you view the confiscated property as just the interest, that is something that produces almost the same result. And as you saw in the briefing, we believe that even that model operates to our benefit and requires that the cause of action be upheld.
Well, I guess I don't see why that's true. I mean, if you see it that way, and the property that you have a right to sue about is the concession, that was the thing that was confiscated from you, I mean, the concession expired.
Yeah.
And so you could have sued from 1960 for however long the concession lasted till, but once the concession expired, I mean, you no longer have a property interest. You're just like that bystander that I was telling you about, which is like, there was property that was confiscated all over Cuba, but that doesn't mean that I have a right to be here in court.
Eddie, it's a weird
So
claim.
if I could go back to,
So could you talk just a little bit louder, maybe
sorry.
adjust the mic?
yeah, I'm sorry. Let me take one crack at the seized property as confiscated before moving on to why the remedy continues, even if it's seen as an interest. And that's the nexus that you're looking for is, I think, broader than what you're suggesting, that you need to have a claim in the property, that's the property which was confiscated, and that is defined more broadly. It's defined as the property that was seized, and it reflects Congress indicating that any, the facility, the mine, the factory, that if that's what's seized, that that's off limits from trafficking, that is the enforcement mechanism for having the takings component enforced, and it stops money flowing from Cuba from the exploitation of that property.
And not just a leasehold, Eddie, but one that expired in 2004.
That takes a whole series of interests, and Congress is giving each claimant to that property.
I guess I understand that, but it doesn't seem to me to fit with the statutory language very well, because the statutory language does not talk about trafficking in claims. The statutory language talks about trafficking in property, and clearly the property that it's referring to is the property that the person who's suing owned, and your property is not the entire docks. Your property is a concession in the docks that was time limited.
But the statutory language indicates that ties trafficking into to the property which was seized. I'm not arguing that our claim is the basis for trafficking. It's trafficking in the underlying property to which we have a claim. So any number of claimants can enforce the anti-trafficking provision as it applies to the underlying facilities, the dock facilities. However, if you view the plaintiff's interest as the taken property, it is still the remedy is not tied to the duration of that interest. It's like a takings claim. If my leasehold is taken, whether before or after the leasehold ends, I have an ongoing remedy to be paid for it. And that's the gist of what is being Congress is providing here.
I guess I wonder why that's true, and this will be like my last one. Like, suppose that the docks were split up physically, so that there was a blue half and there was a yellow half, and you only had the concession on the blue half. Then if you came in and said, the yellow half is being used and I want compensation for that, I think, tell me if you would disagree, but I think we would all say, well, no, you can't have that because there's a spatial boundary that applies to your property interest. And so too here, there's a boundary. It's not spatial, so it's not as natural to think about it. It's temporal, but it's still a boundary on your property interest. Once it's over, and you have nothing to complain about anymore, any more than you would have had anything to complain about if you were arguing about the yellow part of the dock.
The commission's determination would let you know what confiscated property was. If you held an interest just in the yellow portion, presumably the commission would have said the confiscated property is the yellow portion. But be that as it may, that
one thing that could be going on here, guys, is there are other people with claims who might be putting some money into the funding for this case to find out what the edges are of how this is going to be applied.
you don't have the ability to pursue your remedy, get a remedy to be paid for what was taken from you just because there's a time limit on the particular
Well, if you put the time limit aside, let's talk about the use limit. So as I understand it, you had a cargo usufruct, right? Your concession was only for cargo and the cruise ships used it for passenger? Am I understanding that correctly?
No, we completely disagree with that. We think that we had plenary commercial control as a result of being granted each of the usufructs. What an usufruct
There was an expert witness brought in in Cuban law who said, I looked at this contract. You only had the right to load and unload cargo, not people.
Your usufruct was for cargo only?
Correct. In fact, Judge Bloom considered the full range of arguments and found that to not be the case. She rejected that cargo limitation. And in fact, we've charged for passenger ships and cargo ships, and there is no there to the argument that the other side cannot point to a single instance where we did not exercise complete plenary control over the docks and the land.
So what happens, this is a question that's somewhat like Justice Kagan's question about divisibility. Your claim that was certified includes not just the docks, but also some office supplies, some office buildings. And I don't know whether those were attached to the docks or not, but in this hypothetical, let's just assume they're farther away and the cruise ships never use them. but they are part of the valuation that you got from the commission. Are they liable for that, even if they never touched that property and even if it was at some remove from the docks themselves?
They are, because that's the property interests that underlie the claim, and the property confiscated was taken when, and the control over those.
What if you had a
Owners.
grocery store too? In the middle of the island, has nothing to do with the docks, but it's also part of your claim. Are they liable for
You
that?
might be hashing that out right now.
The claim sets forth a certain value. The trafficking just needs to be in the property that's taken. That's right, from you. As long as it's your property, as long as one portion of it is, that would extend to both trafficking.
I don't understand that. Is there, I mean, the way this commission worked, would you have had to go and get separate valuations for different parts of the property? In this hypothetical I'm giving you, the grocery store is completely unrelated to the docks. Cruise ship hasn't touched it. And it is the way that it would work, that you could get it all valued in one single claim? Because I guess I don't understand why they trafficked in the grocery store in my hypothetical.
That is right. You would, the owner of those taken interests would come before the Claims Commission and say, here are my taken interests, and I want this claim certified. And whether they are near or far,
Barrett doesn't sound
those
on
would be
board.
the ones that the commission would pass on.
And then the question of trafficking, who is trafficking in those interests is the sort of later question, but the commission has determined the scope of your property interest. I guess I'm a little confused about the questions related to the limitations on your property
like
interest,
her.
because I thought that was what the statute was saying was the purpose of the commission. That when you say, I've had my property interest taken, you go to the commission and they decide whether or not the extent of your interest is just the blue part of the dock or the yellow part of the dock. The later question becomes who is trafficking or is someone trafficking in the yellow part or the blue part? And I think you would say, obviously in this situation, when the yellow part is the dock and the cruise line is using it, they've absolutely trafficked in the property interest that the commission has identified and told us we own.
Told us we own and indicated as off limits for trafficking. And,
I mean,
here-
and the statute says anyone who owns a property interest as certified as by the commission can make a claim that someone is trafficking in it and get relief or get the money that is associated with that activity in the statute. So it seems pretty straightforward to me. I'm struggling.
I think that's right. There's land and there's the three piers. If the cruise lines only used one of the piers, the fact that the other piers didn't get used doesn't mean that they're off limits from trafficking, and it doesn't mean that the certified claims damage amount doesn't encompass all of them.
Robin and Eddie, there's an extra layer here with usufruct, which I'll get to when there's a break.
You might have limited property
It's pretty cool.
in some way, like the property interest
Cool.
that was taken was temporary or whatnot, doesn't impact whether or not you have a claim, and all you need is a claim in order to trigger this kind of cause of action in the statute.
That's correct, and that's necessary to get the statute to work as Congress clearly intended, that if the takings component of the remedy, which, like any takings remedy, continues until there's actually a payment for the taken property, that if the locking up of the docks doesn't continue until that remedy is provided, Cuba has no incentive to pay. That's the whole point of the statute, and your stolen property is exploited.
Thank you, counsel. Justice Thomas, anything further? Ms. Alito?
On the time question, when the Foreign Claims Settlement Commission calculated the value of what was confiscated from you, did they calculate how much you were likely to have received as a result of your concession during the time period of the concession, or did they calculate how much you would have received if the concession had remained in effect up to the time when they made the calculation?
if I understand the question correctly, the
Thanks, Sylvia. Yeah, share the live, guys.
commission noted
Tap your screen.
that the docks and related rights were to be turned over after an additional 44 years, and that presumably factored into their valuation calculation. It's not entirely clear that that's the case because of the methodologies that they used in terms of book value and the concession and the land. They sort of treated that as having almost a market value at the time. But I can't say that they didn't take into account, because I think they probably did. They treated it as a time-limited leasehold, essentially.
As to the extent of the concession, I think you said that the district court found that it applied to passengers as well as cargo. Judge Bloom rejected an argument that there was this cargo limitation. She viewed the commission decision as foreclosing that, but she went further. She allowed the full presentation of argument based on the legal expert. She considered that, found it to be of no value, and there be no reason to disregard the commission. But then she went further and she looked at the legal. Was that factual question, or that question of sort of contract interpretation, challenged on appeal in the 11th Circuit? Do you regard it as settled, or is it something that would remain open if the case were remanded?
The 11th Circuit expressly left that open, and that's open for remand. It did not reach that.
If we think of these
the expert report
piers as
might get reconsidered.
the property that these piers constitute as a bundle of rights, did the Cuban government from the beginning have what would be the equivalent of a fee simple interest in the pier?
Yes,
they have a fee,
yes is the short answer.
and you had basically.
They were like the lessor, and we were like the long-term lessee with a lease.
So what other rights are there in this? What
Right
other
in my
rights
wheelhouse.
are there in this bundle of rights? Besides that,
Besides,
the interest that the right that the Cuban government retains, your concession, what else is there?
there's the physical property itself, the docks, there's the land, there's the
The
concession.
Cuban government owned the land from the beginning, right, or not?
Yes, and they essentially leased it to us, would be our analogy.
Except there's
So we
not
had
a fee
complete
simple,
plenary
because it's
control
not a common
at
law
the time it
country.
was taken, and then our interest was extinguished. And it's that taken interest
I'll get there in a
that
second.
is locked into place and continues over time.
And now you want to recover a certain amount of money from this one cruise ship line. Were there other cruise ship lines that used these docks during the period, and would you be entitled to receive the same amount from every cruise ship line that used the docks?
There were 4 judgments entered against each of 4 cruise lines, and if in the future a cruise line used docks that have been set off by Congress as off limits from trafficking without our authorization, yes, they would be violating the law and subject to the very extensive penalties that Congress imposed in relation to anyone who traffics in property without authorization.
Okay, last question. Do you think this scheme is primarily a compensatory scheme, or do you think it is at least equally and perhaps even to a greater extent a scheme that is intended to tell people stay away from Cuba because we want to put maximum pressure on the Cuban government to democratize?
Important question.
I think the latter is the overwhelming impetus from this. Congress clearly also wanted to give claim holders a remedy because they didn't have one in court, and the international claims settlement process. But this is has a punitive component to it, and Congress is presuming or wants this property not to be trafficked because that's what funds the communist regime. That's what continues the regime in power and
Thank you.
achieving.
Thank you.
Justice Sotomayor?
I'm not sure I understood your answer to Justice Barrett, but I'm more concerned about your last point, because I do think the Due Process Clause would have something to say about a time of any kind of recovery where the most you would have been entitled to was reasonable compensation at the time of the Cuban government taking over, correct? And you can put a 3-level, or you might, it hasn't been decided yet, you were entitled to compensation for the value of what you had at the moment of compensation, correct? Of confiscation.
If there's use of the property, I'm sorry.
Forget
If-
about
if
the
Cu-
property.
if
When it was
Cuba-
confiscated, when it was confiscated, you were entitled to its reasonable value.
Yes, if Cuba paid just an adequate amount of compensation.
Now,
that
if
would
they
release
didn't
the
pay,
claim.
you're entitled to interest up until you receive payment, correct?
Correct.
But what you're seeking is something dramatically different. You're seeking now not one compensation with interest. You're seeking infinite compensation forever. I think that's what might have troubled the court below. Because it's one thing to say, I am entitled to my value from either the Cuban government or from its proxy, the cruise lines, but I don't know what entitles you to ad nauseum compensation for use by everyone forever. Because that's not an interest in that property. You didn't have an interest in that property forever.
With respect, the infinity and beyond point is one that is in Cuba's control.
It doesn't matter whose control it is. There's a due process problem in thinking that you're entitled to multiple recovery from infinite number of people who might use this dock that far exceeds by I don't know how much, what proportion, the amount that you were owed.
The due process concerns are taken account of by notice. Congress, through the statute, and the commission, through defining what confiscated property was, ruled those off limits. Unless there's a substantive problem with that, Congress...
There might well be. There's a substantive excessive fines problem, excessive punishment problem. I mean, this is something that could be left for another day.
We'll be talking
I
about,
understand
I think, tomorrow.
Because that's not what
Maybe
what is
Wednesday.
before us. What's before us is, did you have an interest in the docks? And the answer is yes, correct?
Correct.
You're admitting that that interest was time limited, correct? You didn't own the docks.
It would have been time limited to 2004 had there been no confiscation, but our time limit on that interest was 1960. It ended there.
It ended there, but it wouldn't have gone forever. It went to a defined period of time. So the commission's charge was to value that interest at the moment of confiscation, right?
That's completely true. And for takings analysis,
All right, for takings, it's what was that interest then?
I agree with that.
All right? Now, you said to Justice Barrett that you were entitled to this even if
I'm
they
just sliding the mic up and down, trying not to blow your
used a
ears
piece
out.
of land that wasn't a part of the dock. If it was a store in the middle of the island.
Even if they didn't use it.
Oh,
Like,
yeah, no.
Yeah.
Did you say if the cruise line had used that store in the middle of the island and it wasn't a part of the dock, you would be entitled to compensation?
Correct. That is what is ruled off limits. That's the seized property that resulted in the,
The dock was the seized property, not the store.
well,
And what did the
Our-
store have to do with the dock? That's what I'm trying to get to.
the store would have been seized as well. And that's where you look to the FCSC's decision.
Oh, now you're talking about that the contract, that issue would have included the store as well? Is that the
If-
presumption you're making?
If the FCSC had considered and ruled that Cuba's confiscation extended to the grocery store as well and was part of our claim, then yes, just as if there'd been...
It was part of what was seized from you.
Correct. And so
Okay.
I'm assuming that our grocery store got seized as well.
Because Justice Kagan's question was, if that store had not been part of what was seized, you would not be entitled to compensation.
Well, there's two issues. We would be entitled to compensation according to the scope of the damages set forth in the FSIA's claim. There's a separate issue about whether trafficking in that interest would give rise to liability.
Thank you.
Justice Kagan? Justice Gorsuch?
So pick up on Justice Sotomayor's questions. What is the theory you have of why Congress would enact a statute that allows you to obtain compensation from a variety of American businesses, potentially, that vastly exceeds the value of your property?
Because Congress had at least dual objectives, and the principal one was to rule off limits from trafficking property that Cuba had seized, or the property interest, however way you wish to think about it, because that was what was fueling or stopping the transition to democracy in Cuba.
I think
And
they
that-
sponsored
that
Kavanaugh.
The taking is, the payment in relation to the taking is only going to happen if Cuba has the incentive to do that. And that's why there's an anti-fencing component, too, that is matched to the taking remedy. But they were recognizing the taking remedy and providing an unusual and an unusually large disincentive to be trafficking in property. There's no American company right to be violating the embargo and to be dealing in Cuba. There's no countervailing interest. All the companies, wherever they're domiciled, are on notice of what the scope of the property is, and they have actually, if they need to use it or justify, they can negotiate with the claim holder. They can just seek authorization through a negotiation, or they could just not use it. I mean, those are the choices Congress is presenting to them for extremely important foreign policy reasons. This is the sanctions and claim settlement portions of the Cuban embargo broadly that are at the heart of the commerce power, and the 11th Circuit gave an extremely narrow reading to those foreign policy interests and to the remedy that Congress had provided.
On the lawful travel issue that several of the amicus briefs raise, I assume that remains open even if you prevail here on this issue. And is there anything else you want to say about that at this point? And it's fine if you don't.
It does remain open, but I'll just point out that almost all the trafficking took place during the Trump administration, and even during the Obama administration, there was the regulation they rely on expressly prohibited activities that are primarily tourism.
And last thing, anything on the briefing at least that you disagree with the Solicitor General on?
No, we agree with the Solicitor General's positions, although of course we went on to argue at considerable length that even if the property interest is what the confiscated property is, subject to the trafficking prohibition, that we would still prevail, and it's an ongoing remedy rather than one truncated by the 2004 limit that was extinguished and doesn't exist any more than the benefits we received.
Thank you.
Justice Barrett?
Just one question, and it's about valuation of the claim. So I know when you have the commission having valued the claim, that's presumptively the value. But let's say that liability is established. The cruise lines come back and they can challenge that, right?
They can challenge the valuation
They can
amount?
challenge the valuation amount.
No, they cannot.
I thought they could.
Congress made it clear that all determinations of law and fact that the commission determines in the claims process is conclusive and final, not subject to review in any court by mandamus or otherwise. That's section 1623H.
Okay, I thought there was an ability by, some heightened evidentiary standard. I don't have
Yes,
it right
no,
in front of me.
what
I don't
you're
think she
referring
likes
to is that there are three types of valuation. One is the amount of the claim. Another is if a special master has made the determination or the commission in the course of considering a claim that's not certified. And then the third is a fair market valuation. But it's the higher of any of those. So that's really only a plaintiff's right to secure.
So the defendant has no rights in that. And I mean, I'll tell you where I'm going with this. I mean, it's just kind of unbelievable to me that in the grocery store hypothetical, that if you had these disparate interests all over the island and your claim, and that was the property taken, that someone who uses the docks is going to be liable for the value of the grocery store, and let's say you also have gas stations, let's say you have lots of things because you just happen to be someone with wide-ranging property interests. You're saying there's no way for the defendant to get out from under that huge liability, which is just because of the chance that you happen to have wide-ranging interests on the island. It could just as easily have been docks and somebody who owned nothing but the docks.
That's right, but the chance they have to get out from under that liability is to not traffic in confiscated property deemed off limits at all or without our authorization.
Okay, thank you.
Justice Jackson?
Just to follow up on your response to Justice Barrett, the chance they have is to say we're not trafficking as the statute defines it in those particular property interests. So it's fine, the person might have a grocery store and set of other interests, and this is the cruise line and they're only using the docks. The cruise line's response is we're not trafficking in the grocery store per the statute, and someone like us would say you're right. But here, the cruise lines are trafficking in the sense, there's a definition of traffic: sells, transfers, distributes, dispenses, uses, whatever, right? So the argument, I think, is that the cruise lines are trafficking in the ownership of the property at issue here as determined by the FCSC, which is the ownership of the dock interest. Is that right?
That's absolutely, our claim relates to the docks themselves, the confiscated property.
Which you
And
own the claim to, because the FCSC said you're the owner of the use of the docks.
That's exactly right. And the point that you're making about the trafficking definition more broadly, I was using shorthand in talking about authorization, but the trafficking definition excludes from liability.
Justice Barrett does not seem into this
any use
at
of
all.
property when the person undertaking the actions that are otherwise
And yeah, everybody hit like,
secures the
tap your screen,
authorization of the
do all that stuff.
Thank you.
Follow
Thank you,
me.
counsel.
Check out my other socials. Okay, real quick, guys. There's something called usufruct. We are a common law system. Other countries are civil law systems, like Cuba. They are more rooted in Roman law. Usufruct,
Brown?
it means that you have the right to use whatever the land gives you. Use of the land, so you get the right to use all the oranges that come off of the orange trees on the land. That is the right that they were given to these docks.
To use those same docks, respondents trafficked in property which was confiscated.
Everybody's
Congress
quiet.
gave petitioner the right to seek damages from respondents because petitioner owns the certified claim to the docks. Petitioner's suit can proceed
Something's just wrong with the
regardless
audio
of whether
today.
you think of the relevant property as the physical docks or as the right to 44 years of possession, control, and operation of the docks. Either way, respondents were complicit in Cuba's exploitation of property before Cuba either provided compensation or returned the property to petitioner. The Court of Appeals rejected that analysis by considering the confiscated property as if there had been no expropriation, and then asking whether petitioner would have had an interest in the property at the time of the trafficking. That test undermines the scheme that Congress enacted, which expressly protects time-limited interests and which is aimed at providing a remedy for Cuba's expropriations, not pretending they never happened. I welcome the court's questions.
Who owns the docks?
So at all times relevant here, the Cuban government had the underlying ownership of the docks, but they had provided for control of the docks and possession of the docks to go to petitioner for the term of the usufruct.
So how could Cuba confiscate docks that it owned?
The statutory definition of confiscated refers to seizure of ownership or control of the property. And so while the Cuban government owned the property at this time, they did not have control of the property. That's why, in order to effectuate the expropriation here, they had to send government agents, armed soldiers, out to the property to take back control of the physical docks from petitioner. We think that qualifies as a seizure of control under the statutory definitions here. You could imagine this like a car lease, for example. So say I have a lease of a car for a term of 2 years from a dealership. The dealership decides after 1 year that it wants to take the car back. I think it's perfectly natural to say that they seized the car, even though they had the underlying ownership of the car at all times.
Do you agree with petitioner's position on the grocery store hypothetical?
No, we don't. We don't think that you have to just take the certified claim and every interest that's reflected in the claim as given. I think the Claims Commission does lay out, as Justice Barrett noted, that there are facilities here, there are office space, there's equipment. Each of those is valued separately, and so you have to be trafficking in whatever interest or in whatever property is at issue. And you don't get to just kind of bundle everything together necessarily just because of the way that the claim was set out or the way that it was certified.
So if we're not looking to the Commission's understanding of what the claim is, and we're just focusing on what it means to traffic in the property which was confiscated, again, I would think the property which was confiscated is the property which was confiscated from you, the plaintiff, and that's a time-limited concession. And the time, it's gone. It's gone by now. It doesn't exist.
So I do think that it is relevant that the property which was confiscated doesn't say that it has to be the property which was confiscated from you. It's the property which was confiscated to which you hold the claim, and we know that the claim reflects
Oh, no, I don't think it does say that. I mean, you could have easily written a statute which said, you know, the property in which you hold an interest. And that would have directed everybody to say, okay, they're not talking about the property interest that you own. They're talking about sort of like the underlying piece of land in which you have some more limited interest. But that's not the way this statute is written. This statute is not the property in which you have an interest. This statute is the property that's confiscated. It has to be the property that's confiscated from you. And that's like not the docks. It's just the time-limited interest.
So I do think that a claim reflects the interest, right? And the confiscated property can be confiscated even if you didn't have the ownership of it. So I think putting those two things together, you can get to where I was suggesting, which is that you have to own the interest in the property which was confiscated. But even if you disagree with me, I do think that we get to the same place. And that's because you look at the property which was confiscated at the time of the confiscation. So that is the 44 years of the rights to possess and control and operate the docks. Those 44 years don't continue to run because they disappeared at the date of the expropriation. It's like Cuba here is cutting in line in front of petitioner and exercising the rights that petitioner was supposed to be able to exercise for another 44 years, and respondents are complicit in that by paying the Cuban government for the exercise of
But if that's true, I mean, I do think that the 11th Circuit is right, that you're converting a time-limited interest into a perpetual interest because of the seizure. The seizure, like, nobody's defending the seizure here, right? But the question is, like, what does this compensation scheme entitle you to as a result of that seizure? And you didn't have a perpetual interest, and now you're saying because of the seizure, because your interest was interrupted, we're going to treat you as if you did.
I don't think that's right. I think at the time of the confiscation, this 44-year interest is distilled into a claim, and that claim entitles you to recover for those 44 years or to get those 44 years back, and until you either get the compensation for the 44 years or you get 44 years returned, you do have the right to sue anybody who interferes with that. And Cuba and respondents are acting in concert to interfere with the right for those 44 years.
Ms. Brown, I understand your point that the interest isn't the docks, it's the use of those docks for 44 years that are reduced to a claim in value. Mr. Klinger suggested, though, that I can recover that amount over and over and over again. You've handled the grocery store hypothetical. How about that one?
So before the Court of Appeals, the respondents here have argued that the statute should be read to incorporate a single recovery kind of rule so that petitioners here could only receive the value of their claim a single time. That argument is still open on remand. Judge Brasher, in his dissent, appeared to adopt the argument, although he didn't explain any of the basis for that. So that is an argument that you don't need to resolve today, but to the extent that I think there's a multiple recovery possibility here, I don't think that that should dissuade you from reversing in this case, because that does reflect that this is not a purely compensatory regime. It's a foreign policy tool
Janine,
that
I'll
Congress
respond to
is
you in a
using in
second,
order
'cause you
to
have a very good
deter
point.
trafficking and to impose harsh economic pressure on the Cuban government.
So let me see if I've got it right. I don't have to touch it, for which I'm truly grateful.
Correct.
But the government does believe it allows multiple recoveries.
We haven't taken a position
Okay.
expressly in the
Okay.
briefing on this, but But to the extent that that's a possibility, I do think that that's just reflective of the foreign policy, the significant foreign policy interests here.
Got it.
Do you have a position? You said
No.
the briefing doesn't expressly take a position. Does the government have a position? It would be odd if the government didn't have a position on such a significant foreign policy question.
So we do think that the foreign policy interests here do suggest that Congress wasn't particularly concerned with multiple recoveries in this instance. And I think that that is because if you look at the congressional findings as to foreign policy in section 6081, in particular paragraph 6 and paragraph 11, this is 10A and 11A of the appendix to our brief, Congress sets out that trafficking and confiscated property provides the Cuban government with badly needed financial benefits, including hard currency, and that provision of those resources undermines the foreign policy that's encompassed within the economic embargo, that pressure that we're trying to
Cuba
apply
and
to
maybe
the Cuban
Venezuela.
government in order to persuade it to return to democratic regimes. And I think that allowing for the fact that some companies have paid off the claim to mean that then they can continue business with Cuba and continue paying Cuba millions of dollars, that really undermines that foreign policy interest. This isn't supposed to be a cost of doing business for companies. It's supposed to be a poison pill that essentially deters them from ever operating with Cuba, at least with respect to the confiscated property, unless and until the Cuban government returns that property, provides compensation for that property, or otherwise returns to democracy.
Except then
Could
that
we
poison
also
pill was
glean
stopped from
the
being used for
enactment
25
history
years.
here what Congress was really trying to do? And that is not necessarily set up a compensation scheme, as has been said, but the fact that the Cuban Claims Act, which initially created the Foreign Claims Settlement Commission in 1964, just a few years after all this property was taken, but didn't give a remedy, suggests to me what Congress was doing was really freezing and trying to highlight the fact that this property is taken, that it has a lot of value, and we're going to set up a system to prevent Cuba from trafficking in it. It did not, at that time, sort of the initial thrust of this, focus on how much anybody was going to get or the people whose property had been stolen, what is the avenue for recovery. That wasn't the focus. It was to try to keep Cuba from trafficking in this property.
I think that's exactly right. That's reflected specifically in section 6081 in paragraph 11. Congress notes there that there is no existing judicial remedy for the victims of these confiscations and that it wanted to provide such a remedy in the federal courts of the United States.
And then when the remedy comes along, I mean, it may seem pretty draconian to suddenly give multiple recoveries to all these people, but if you think of it in light of Congress's intention to really, really make it hard for Cuba to traffic in these properties, that kind of a sanction makes at least some sense.
Yes, that's exactly right. This was intended to be a huge deterrent. It wasn't intended to be something that people actually ended up paying because it was supposed to make them think twice about ever getting involved in these kinds of transactions at all.
Thank you.
Thank you, counsel. Justice Thomas?
Somebody mentioned that this might be a
To how far Congress can go with this sort of poison pill remedy.
As Justice Sotomayor mentioned, there are some due process concerns, I suppose, that could be raised to the extent that the recovery so far outweighs something else. I think that nobody would kind of bat an eye at this if the recovery was just going to the Treasury instead of going to petitioners. Respondents here have raised due process concerns as to the remedy as well. That is another issue that will be open on remand to the extent that the court has further concerns with that there.
Justice Alito?
Somebody asked if we could just buy the whole island. One of the guys who worked with the guy who brought this case claims to own like 82% of waterfront property in Cuba. So it's not that far from reality.
Period, or what does the statute say about that, or does it say nothing about it and leave it to the commission?
So it says that the commission is supposed to understand or figure out what the property interest here was and then value that in the way that's the most equitable, undertaking considerations of fair market value, book value, replacement value, things like that. I think you can see from the commission decision that they were very well aware that this was a 44-year time-limited interest and that there's every indication that that was taken into account in the way that they were valuing it.
Sotomayor?
I'm not sure you're answering the question. Your answer earlier made it seem as it wasn't 44 years. that it was infinite until the Cuban government gave the property back, it gave back 44 years. So how could the commission value it on 44 years when it, by your claim, it's infinite?
So the claim.
Until Cuba acts.
The
To
claim
infinity
continues to
and
exist,
beyond.
and the claim continues to be able to be enforced until then.
You know
But the
something
value
that,
of the interest.
when I think of claim, I think of like a lien, all right? And I thought that analogy in one of the briefs was very useful. I lend someone money. Sometimes I lend it for purposes of that property, but often I lend it for the person to use it on something else. But I take a lien on property. That means that that lien exists until somebody pays it off, all right? And if someone buys that property and knowing the lien exists, they have to pay me, even if though they may have given the full value to the owner, the full owner. And that's what I think this law is like, correct?
I think that that's a helpful analogy, yes. We think that the property interest is reduced
So
to the claim.
what the commission did was value that lien, correct?
Yes, they value the 44 years.
All right. When I read the law, or the snippets of it that were given to me, it seemed to say that the respondent could challenge that the value was presumptive that the commission gave, but that they could fight it if it was not right, correct?
So I don't think that that's correct. The way that I read that is that the presumption is that the Claims Commission's valuation is going to be the amount that you recover. You can't challenge what their valuation was, but you can challenge whether that is the right amount to recover or
That's
whether
what
you
I
should
mean.
instead recover fair market value.
Yes, exactly.
Yes,
Okay,
that is
so that's still open. The other side said no,
So
that it's,
To the extent that that's what my friend said, I think that that's incorrect, but I do think that you would have to show that the fair market value is the greater of the amounts, because the recovery is for the greater of the claims certified amount, the other amount that the special master determines, which isn't relevant here, or the fair market value. But if you can show that the fair market value is greater and is the appropriate amount to be applied in this situation, then that's what's going to apply.
I see. So he's right. Okay. That's what I needed to know.
Justice
And-
Kagan? Oh, I'm sorry.
No.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Do you want to say anything on lawful travel? In particular, the story on the other side and in the amicus briefs is that they did this at the encouragement of the United States government, and that they consulted with the United States government, who told them they were good to go. I'm paraphrasing. They say that's lawful travel, and I notice in your brief you don't take a position on that. Do you have a position on the lawful travel in this case?
So the government has not made a determination in this case as to whether the particular activities here constituted lawful travel, whether they were within, I think, the general license that respondents were purporting to operate under. We have in other cases.
They were told that previously, weren't they, by the government?
They say that they were.
She was
Again,
good for a minute. Now I can't hear her.
we haven't made any kind of determination that that is correct. To the extent that respondents received assurances from appropriate government officials that what they were doing was lawful and authorized, we do think that that would raise due process concerns. To the extent that the 11th Circuit wants the...
Like huge ones, wouldn't it?
To the extent that the 11th Circuit wants the government's position and determination on those issues, the 11th Circuit has, in prior cases involving lawful travel, asked for the United States views on those kinds of questions, and we would be happy to provide them at that point. We haven't provided them here simply because it's not a part of the question presented.
Thank you.
Justice Barrett?
So you agree that would be open on remand?
Yes, definitely.
Okay, and then just one question. Let's say that I agree with you about the time question, and I think it has to be gauged at the time of the confiscation. I just want to go back to that use question I raised before. So there's this dispute about whether it was cargo only or if it was passengers too. I mean, the statute repeatedly talks about the property that was taken. And I took you to agree with that insofar as you distanced yourself from your friend's answer to the grocery store hypothetical. If it turns out on, let's say it's open on remand, that really it was just cargo, then does that mean that the cruise lines did not traffic in the property if they didn't use it for cargo purposes?
So, not necessarily. I do think it depends on first what you think of the property is, because if the property here is the docks and they had an interest in the docks and someone trafficked in the docks, then their interest would reflect that their interest was limited just to cargo uses and not to passenger uses, and that would be connected to the valuation, but it would still qualify. But I think the cargo versus passenger thing here is kind of a red herring, because even respondents have acknowledged that if petitioners had the exclusive control of this particular piece of property, if someone used it for a different purpose than they did, that would still be infringing, I think, on their right to use. This is the hypothetical with like the building where one floor, where you lease it out and there's a use restriction and it can only be used for office space,
Right.
and then someone comes and uses it for a restaurant. Everyone agrees, I think, that that's still trafficking in confiscated property. So the real question here is whether this was an exclusive right to the docks or a non-exclusive right. And on that, we see nothing in the record that would indicate that it was non-exclusive. Certainly, the Court of Appeals didn't take that position. Otherwise, there would have been no need to remand for further consideration of the trafficking that had occurred before 2004, if this was a completely non-exclusive interest that could have allowed for others to use.
And isn't it the case that part of the value is that they had invested in building the dock? So it's not just like the car lease where I was going to have to keep paying monthly, and then
There's
you
your
take
answer.
the car, and then what have you really lost? But here, it was like their consideration was that they had a lot of money invested that they never got back because Cuba confiscated
They
it.
built
That's
the
exactly
docks.
right. They built the docks. The payment for the docks was supposed to be the right to operate and commercially benefit from them.
Mrs. Jackson?
Can I just get you to quickly explain the role of the certified claim in your analysis? I'm concerned that we might be led to reason from first principles about property law in general, when really the certified claim process, which is in this statute, is doing very important work.
I certainly agree with that. The certified claim is going to set out what the property interest was under the appropriate law, which I assume would be taking into account the Cuban law that defined the scope of the property interest. They looked at all of the record documents that explained the extent of what the usufruct here was, the extent of the concession, the time limits remaining on that, and then they valued that based on the remaining life of the concession and what value was supposed to be able to come out of that.
And what they gave as a claim, as I understand it, never said this terminates or evaporates or something happens to it in the same way that the property interest would have expired.
Yes, that's exactly
The claim
right.
doesn't have any sort of termination provision in it. They were just valuing what the underlying property interest is and giving them a claim. And then the statute here says if you have a claim, you get to make this kind of, you have this kind of cause of action, right?
That's correct. The claim essentially encumbers the property, as the lien analogy goes, and that property is treated as tainted. Anyone who transacts with, engages with, benefits from that property is then trafficking in that property, and the claim holder has the right to pursue that.
Thank you.
Thank you, counsel. Mr. Clement?
Mr. Chief Justice, and may it please the Court, Title III of the Helms-Burton Act provides an action against someone who traffics in property which was confiscated from the Cuban government. Property is a defined term in the statute that includes any property interest, including a time-limited one like a leasehold. And then the Act gives a cause of action to someone who has the claim to such property, i.e. the property that was confiscated. The plain text of the statute requires a one-to-one correspondence between what was confiscated, the property interest that was confiscated, and the property interest that was trafficked. So if all that was confiscated was the mining interest in a property, only somebody who traffics in the mining interest, not somebody who harvests timber on the property, is trafficking in the property interest that was confiscated. The same principles apply to time limits on the property. So if someone had a 50-year leasehold in the property, anyone who traffics during the leasehold traffics in confiscated property. But someone who arrives after the leasehold has run might be subject to a claim by the landlord, but not to the leaseholder. And basic principles of property law reflect those same distinctions. Tahoe Sierra says that both the spatial and the temporal limits define the metes and bounds of the property interests. And so with respect to what's at issue here, I think it's clear, as suggested in the response to Justice Kagan's hypo, that with respect to the spatial limits, this is obvious. You can't, if somebody traffics in your neighbor's property, you don't have a trafficking claim against them. But the same things apply temporally. And here, it should be common ground that the only interest that petitioner had in these docks was a concession that expired in 2004. Someone who arrives later is not in a position to traffic in the property interest that was confiscated. There's not the one-to-one correspondence the statute requires. I welcome the court's questions.
If I had a lease in property, if I leased property, and how would that lease be confiscated?
So the lease would be confiscated in the sense that, I assume that what would happen is that the Cuban authorities would come in and they would take control over the facilities, and then in the process you would say they confiscated the leasehold. That's the way it works in domestic takings law. And in domestic takings law, there is such a thing as a taking of a lease, but of course the value of the lease reflects its time limit. And what we don't have in domestic takings law is this idea that under certain limited circumstances, there is a substitute payer that pays the person who had their property taken in lieu of the government. And that's the unusual regime that Helms-Burton creates. But the only person
Helms-Burton
who is in a
is the
position
Libertad
to be
Act.
that substitute payer is the person who traffics in the very property interest that was confiscated by the Cuban government. If there's a mismatch...
But the statute doesn't say property interest. It says traffics in property which was confiscated. You would more naturally think that it was speaking to property that was the basis of the lease.
Here's the problem with that, Justice Thomas. Property is a defined term in the statute. So when you read property, you go to the definition, and it says any interest in the property, including leaseholds, including future interests. So we're clearly talking about sticks in the bundle, and that makes sense. I mean, if any stick in the bundle is confiscated, then it makes sense that you get compensation. And under this unusual regime where you put somebody as a substitute payer, it makes sense that you put the substitute payer in that position only if they traffic in the stick in the bundle that was confiscated. So it's the example I used with mineral rights, and that's a real-world example. Some people, their only interest in property that was taken over by the Cuban government was a mineral interest. Well,
So what would be the interest if you owned it fee simple?
then it's easy, you own the whole thing. And then you do have the perpetual ability to go after people who later traffic on the property. But as the 11th Circuit held here, if you ignore the time limits on concessions or leaseholds, you end up sort of treating relatively small sticks in the bundle as if they're the whole kit and caboodle. And that doesn't make any sense, and it really doesn't make sense, particularly if you understand that nothing about our position makes the confiscation end or goes away, makes the claim against the Cuban government go away.
But it also seems quite difficult to pinpoint the interest, the particular interest in property. It could be a very small interest. I could lease a closet in a huge facility, and somehow I would have to pinpoint that.
Well, in theory, it could be difficult. In practice, what you principally see, if you look at the claims, is you do have some leaseholds, but only a handful. I mean, this whole case is about, like, the government in their brief at page 29 identifies a grand total of 5 time-limited interests among the claims, 3 leases and 2 patents. So we're talking about a pretty small universe here of the time-limited ones. But the time limits are crystal clear. If you went and looked at the Claims Commission order here, you would see that it ends in 2004. So there are ones where you'd have very clear notice. I do want to talk about Justice Barrett's hypo because it's not a hypo. If you look at the claim here, it didn't just cover the docks. It also covered 1,000 shares of Cuban telephone stock, and it also covered about $300,000 in repudiated debts. Now, the district court awarded them the whole $9 million, even though there's no question that we didn't traffic in Cuban telephone stock, and there's no question that we didn't traffic in the confiscated debts. And the confiscated debts are important for another reason, because I don't think it's actually possible to traffic in confiscated debts. Yet that is probably the single most recurring claim that's reflected in the Claim Commission's decisions. Because what happened is not only when Cuba owed money to U.S. companies, it wasn't going to pay, so you have all those repudiated debts. But then you had the other problem, which is a lot of American companies had accounts receivables from other American companies that were expropriated.
Mr.
All
Clement,
of that's part of the confiscated property. I'm sorry.
I'm following you, but I struggle just a little bit. The docks were confiscated, right?
Well, the petitioner's time-limited
No.
interest in the docks were
The
confiscated.
docks were confiscated.
I can't agree to that with all due respect.
Really?
Because Cuba owned the docks. So the only thing
Okay,
that
they
was
confiscated
is part of the
control of the docks. Okay, they confiscated control of the
different.
docks, right?
Under civil law.
confiscated the concessionary interest. They actually, with all respect, I'm not trying to be difficult, though I know I am being difficult.
Well, just a little bit, but that's okay.
No, but the thing is, we don't concede. The government
Civil
came
law.
up here and said they had a right to control the docks. That is directly contrary to the position that we took in the district court and that we appealed to the 11th Circuit.
All right,
Our position is,
Mr.
they had
Clement,
no
let me-
control of the docks. They just had a non-exclusive.
Fine.
cargo
There's
concession.
a disagreement over exclusivity. I understand that. But for purposes of this question, let's put that aside. There is confiscation of a property interest in the docks. How about that? Can we agree on that?
We're together.
Okay. And there's no question that your client has used the docks.
We have used the docks. I
Okay.
agree with you. We just
All
haven't
right.
trafficked in that which was confiscated.
Well-
The time-limited concession.
And there's a claim with respect to those docks.
There is. The claim reflects the time limit. And if you look at the claim,
And the claim reflects the time limit. Okay. All right. So we have confiscation, we have trafficking, and we have a claim. What's missing?
what's missing is the overlap between the property interest that was confiscated and the property interest that was trafficked. So the property interest that was confiscated was a time-limited interest.
Where do you get that from? It says traffics in property which was confiscated.
Civil law.
Any property of any kind in which was confiscated. Yeah, got that.
Right, but then you
We
keep
have
reading,
trafficking.
and when you
Got
keep
that.
reading,
I've got it right all. I've read it and read it.
And if you keep reading, it says that you shall be liable to any United States national who owns the claim to such property. And the such property is plainly referring back to the property which was confiscated.
Yeah.
QED, with all due respect, this statute requires a one-to-one
Property they have is a usufruct.
was confiscated and what was trafficked.
I think I follow all of it except for the QED.
What's that?
I think I follow all of that except for the QED.
I thought that might be your response, Your Honor, but I really do think that if you read the statute, it says that the person who can bring the action is the person with the claim to such property.
But Mr.
Such
Clement,
property
Something's
has
wrong
to
with the
be
mic today.
why isn't the
Not
claim?
on my end, on their end.
Oh,
Sorry.
Refers to property which was confiscated, and so that
I've been
kind of
messing
goes
with it
back
all
to
day.
Justice Gorsuch's point, because the such property refers back to property that doesn't have an article in front of it. It doesn't say the property that was confiscated. It says property that was confiscated, making it seem broader.
No, I don't think so, because again, property is a defined term in the statute. And so property includes any property interest that you have in the property. And then
No, but it doesn't say that, though. It says any property, and then when it gives the long list of kinds of property, I read that definition to say essentially any kind of property. So it can be intangible, it can be a patent, it can be a leasehold, et cetera. But it doesn't say, a
This
couple
is
of times you put in
technically
interest before it,
intangible
any
property.
interest in property, but it doesn't say any interest in property. It says any property.
So with respect, it says any property, and then it talks about specific
Right.
limited interests in property. And so I'm reading it, and I don't think it's a leap to say that it's being inclusive and it's saying any interest in the property.
Mr. Clement, where I,
And then
Go ahead.
Could you just
Sorry.
finish, if
Yeah.
you could just finish for me?
I like that he
it says
stops
that
when
the person
they-
with the claim to
Some
such property
don't.
gets to bring the action. And that's important, because otherwise you could certainly have a situation where different people have different property interests in the same property, the same physical location, and you don't want to let one of them bring a claim for the other person's claim in the property. And the statute would kind of be chaotic if you did that, because it allows you to traffic if you have authorization. Well, presumably you need to get authorization from the person who has the exact interest in the
I didn't say
property
it.
that you plan to traffic in. And similarly, there's a provision in the statute A5D that's worth a look, because that provision suggests that basically once somebody brings one of these actions, it's exclusive to anybody else bringing an action in the property. Now again, if property means a specific slice of the bundle, a specific stick in the bundle, statute works great. If I have a leasehold and somebody traffics during my leasehold, I can bring an action for my leasehold. But I don't get to give authorization for trafficking years later and interfere with somebody else
Mr. Clement,
who's got the fee interest.
Mr. Clement, why doesn't the statute also work great if we understand that it has a provision that gives some authority to the FCSC to tell us what the person's property interest is? It seems to me that your analysis has at least, I counted 2 problems, but that's really the main one, in that you're trying to get us to evaluate what the person's property interest is when this statute gives that responsibility to that agency. That is, in fact, all that agency is supposed to be doing is listening to the arguments that you're talking about and deciding what this company's, Havana Docks' property interest is. And once they've decided that, they said, you have a claim to enforce the interest as we've defined it. And the statute then appears to say anybody who has a claim can come in and try to recover in this way. And the other thing that I think is missing from your analysis is that nothing about the statute says that the scope or extent of that claim is tied to whether their property interest was temporary or limited or anything like that. And that's the way you seem to want us to read it. You cut out the FCSC in the analysis, and you say, but they only had a limited property interest, so that expired before we arrived, and so they don't get to press their claim. There's nothing in the statute that says the claim should be evaluated based on what the property interest was. The FCSC does that. They tell us this person has a claim, they evaluate all of the limitations, and then the statute operates perfectly.
So with respect, Justice Jackson, we're not fighting what the commission certified. What the commission certified was actually a time-limited interest. And if you look at, that's obvious at Joint Appendix 259, because they say it expires in 2004, but it's even more obvious if you look at page 256 of the Joint Appendix, is on the basis of a concession.
Right, but what they don't say is that the claim that we are certifying today has the same limitations as the limited property interest that we are evaluating. That's the thing you're missing, I think, in order to make your argument work.
I don't think so with respect, and I think it's no different if I can take Justice Kagan's hypo. If the Claims Commission looked at this thing, and I forget whether it was the blue or the yellow, but if the Claims Commission said, you got the blues, that's great. And then if somebody traffics in the blues, I have a claim. Now, I want to say if you traffic in the blues, you don't get the claim to the Cuban telephone stock, but that's a separate issue. But you get what is specified in the claim, but you don't get a claim over the yellows just because you...
So why didn't you traffic in the blues? I understood you to be trafficking in the blues for the purpose of this hypothetical.
Well, but what I'm saying is by parity of reasoning, what happens for the spatial limits of the property interest have to apply to the temporal interest in the property. So think if there were like 2 stacked leases, 50 years and then another 50 years. If you traffic in year 45, you have a trafficking claim against the person who owned the first leasehold. But if you traffic in year 55, you have a claim against the person who owns the second leasehold has the claim against you, but the first one doesn't. And keep in mind, there's nothing terrible about that. This statute, Congress didn't think it was giving a trafficking claim to everybody who had a claim against Cuba. There are lots and lots of claims that by the nature of the property, you're not going to have...
No, it didn't think it was. It didn't think it was giving a claim to everybody who had a claim, giving a claim that could be asserted in court to anybody who had property confiscated by the Cuban government. But isn't what Congress said this, as applied to this case? Havana Docks had a concession for 44 more years, and that had a value. And the Cuban government has not compensated them for what they've taken, and therefore nobody is to use that concession in the future. Nobody is to use the property interest that was the subject of that concession in the future until there's compensation from the Cuban government. It's not so. You go into this with your eyes open. Now, maybe you were misled by the government. That's another story. But if your client came to you and said, we're thinking of docking our cruise ships. What's the Helms-Burton Act going to mean for us? I mean, a lawyer like you would say, whoa, you're taking a big risk.
Well, I would say, yeah, it's a close question. We might end up in the Supreme Court of the United States. But I would say, I'll tell you what
I would bet you would not, you would not advise them full speed ahead, and we'll litigate this in the Supreme.
What I would tell them is there might be reasons to be somewhat cautious, but my best reading of the statute is you don't have anything to worry about after 2005. And the reason I say that is because, first of all, the statutory text specifically says that you have to traffic in the property interest that was confiscated. Now, obviously, I've pieced together some pieces of the statute, but I think that is the best reading, that you need the one-to-one correspondence. And then I would say, look, I pulled the claim. And when I pulled the claim, I saw that the only basis for a claim to ownership of the docks was on the basis of the concession. That's Joint Appendix 256. And then I keep paging through, and at Joint Appendix 259, it says that expires in 2004. So I would say, look, there's a lot of money under the statute. The way the petitioners interpret it, there's an enormous amount of money under the statute. So you may get sued, but if you want my best answer is you're in the clear after 2005. And like I said, that doesn't really distinguish it from a whole bunch of other property that Cuba confiscated. From the Sabatino case, they confiscated sugar. It's a perishable good. The sugar that was confiscated in 1960 is not available for trafficking anymore. That doesn't mean that the claim to the perishable good it doesn't mean that it wasn't confiscated. It doesn't mean that the people in Sabatino don't have a claim against the Cuban government. It just means that in the nature of certain property interests, there will either be very little sort of window for trafficking in that same property interest, or there'll be none at all.
Well, if your reading of the statute is correct, it's argued it would make hash of the coverage of patents. And that does seem to me to be correct. Why is it not?
Well, it's not for two reasons. One is because the universe of confiscations didn't stop in 1960. So as at least a theoretical matter, and that's what you should be looking at if you're worried about deeming terms superfluous in a statute, you could confiscate patents going forward. But the second reason is...
as a theoretical matter, Congress included patents because it thought that even though all the patents that had been issued to Americans in Cuba before the Cuban Revolution had expired after 17 years, somebody here might go to Cuba after the enactment of the Helms-Burton Act and get a patent on something under Cuban law, and then the Cuban government might subsequently confiscate that patent. That's why Congress included patents in the statute.
So I think, in fairness, I think Congress included patents in the statute because it wanted to be comprehensive of all interest in property. But I don't think it's a far-fetched hypothetical to say that somebody might have illegally left Cuba from the Cuban government standpoint, had a patent, and that patent was canceled, and that might be something that they could bring an action to. The other thing I will say is, look, the government looked through all these claims, and they found, even in 1960, they found only 2 claims that involved patents. And I do think this does underscore the point that Justice Barrett alluded to, which is it just can't be right that if you traffic in anything that's covered by one of these claims, that you get to recover the full amount of the claim. Because one of the 2 patent claims that they point to on page 29 of their brief, I looked it up, it's ITT. So ITT was one of the largest sort of confiskees, if you will, and the total amount of their claim is $500 million. The value of the patents that were confiscated is $7,000. Now, first of all, I think the reason we're right about patents is because I think it's weird to create a perpetual patent. But if you assume that that's the right answer, and so that patent becomes the super patent, and it continues to apply, and somebody infringes on one of ITT's patents...
ITT was the massive,
they can't be entitled to
weird conglomerate
$500 million in the claim.
owned by the grandfather of the people who now own the Havana Docks rights.
So it has to be that it's not the claim.
It's kind of a crazy story.
The property interest. And you need to have that one-to-one correspondence between that which was confiscated and that which you trafficked in. If you don't have that, it doesn't mean the claim goes away, Doesn't mean the property's not confiscated. It just means that the particular person who arrived at a neighbor's property or arrived at the docks 5 years too late, they are somebody who is not going to be put in the extraordinary position of being the substitute payor of just compensation for the Cuban government.
Why not, putting aside the multiple recovery issue, which I agree with you, gives rise for concern, okay? Putting that aside, why isn't this like a lien? You buy the property, you know that you have to pay for someone who owned the use of the docks before. Now, whether it was exclusive or not, you're a cruise line, you know that the commission has said that they had a lease interest that was at least for unloading cargo, I'll concede that. Why aren't you liable?
Because that's not the statute that Congress wrote. I mean, I too enjoyed.
If I disagree with your construction of the statute, if I see that all you have to have is a claim in confiscated property, and the lease is a claim on the docks, whether you want it to be a claim on the docks or not, it is, because the lease is of the docks.
So I just can't find that in the statute, and I too enjoyed the brief, and I enjoyed the reference to lien, and I enjoyed the reference to encumbrance. And if I found either of those words in this statute, I might think they.
It defines property as liens.
What's that?
The statute defines property.
It
as
might
liens.
include liens, but it
Lien
doesn't
holds.
make the claims liens. It doesn't make a claim commission claim a lien on the property. It doesn't make it an encumbrance on the property. It doesn't do all of those things. And of course, I don't need to tell you, liens are like interesting creatures. They don't require you to have any real interest in the property. If I have a mechanic's lien on a property, I don't have to have any interest in the property. So I think if Congress wanted to come up with a lien regime, then it would have written a different statute, and I would have given different advice to the client in Justice Alito's hypothetical. I would say, yeah, that's the same address.
All right, thank you.
Mr. Clement, why wouldn't, so part of the intuitive appeal of your argument is it feels unjust, right? Putting aside the statutory language. I mean, it feels unjust because the multiple recoveries possibility and because this was a time-limited interest. But the time-limited nature of it is presumably accounted for in the valuation. And I don't see what's wrong with Justice Alito's description of saying that if something is taken at the time, so in 1960, Castro takes it, that it then becomes kryptonite. For purposes of trafficking, nobody can touch it. And it wasn't just the lease, because they paid for these improvements, and they were never compensated for those improvements. So I guess I just don't see in the statute, which does talk, I agree with you that it requires a one-to-one insofar as you have to traffic in the property and not the grocery store, right? The property. But it seems like the property is the docks, the use of the docks. I guess I don't understand why that's crazy.
Well, it's not crazy, but it's, with all due respect, it's wrong because it needs to be the particular property interest that was confiscated. And so let's take the hypo with the mineral rights and the timber rights. Maybe it's easier to understand because it's the same parcel. But if somebody goes there and all that was ever confiscated was the mineral rights, and some company goes there and it takes all the timber and takes the lumber away, I wouldn't think they trafficked in the confiscated property. And I don't know why it's different from the time limits. And to the extent the government is sort of suggesting this sort of suspension or tolling rationale, there's two things wrong with that. One is, my friends on the other side, at page 9 of their reply brief, expressly disclaim suspension or tolling. And the other thing is, it's just wrong as a factual matter, because we know from the experience with this particular concession, where from 1906 to 1910, the Cuban government had a spat with Scoville, or whoever was the original developer, and they couldn't move forward for 4 years, and it didn't tack on 4 extra years to the concession. The concession ends, the first one was 50 years, got extended 49 years, which is the maximum, by the way, that Cuban law allowed. So it was always like, it's not a tolling, it's not like, it really isn't 44 years, it really is until 2004. But the bottom line is, Congress could have written a different statute. They could have made it clear that it's a lien, it's an encumbrance. They could have said, no, it's just the parcel. Now, they would have really had to write a different statute, because I think then if you go to 6082A5D, that provision would be written differently if that's the way they conceptualized. And then the provision about authorization, I think, would have been written differently because it doesn't make sense. If somebody had the mining rights and somebody had the timber rights and somebody wants to harvest the lumber, if the person with the mining rights gave permission to the person who took all the lumber, that doesn't make any sense. It's got to be the specific property interest. And if that's true spatially or for mining versus timber, there's no reason that's not the right answer for the basis of time.
Mr. Clement, what's your response to it would have been written differently and in the way that you describe if Congress's aim was compensation? But if Congress's aim is to do what Justice Alito suggested, which is put pressure on the Cuban government, create a sanctions regime, and keep people from trafficking in foreign property or stolen property in this way, I don't understand why the statute wouldn't be written exactly as it is, giving anybody whose property was taken as certified by the FCSC the ability to say, however many years later, nobody should be using my property until I get compensation for it.
Well, first of all, it all depends on what we mean by my property. And I would say my property.
No, can you answer the purpose question? Can you answer the extent to which what we expect to see in the statute, the structure? You keep saying Congress would have written it a different way, but I'm saying Congress would have written it the way you're talking about if they were trying to compensate people.
But you're not saying it has to be compensation, right? There were 44 more years left in which these kinds of suits could have been brought. And that doesn't have anything to do with compensation or not. The suits could have gone wildly over the amount that was that you had at issue, correct?
Absolutely.
The only thing you're saying, you're not saying tie it to compensation, you're saying tie it to the nature of the property interest, and at some point a temporal property interest runs out and you don't have it anymore.
That's exactly right, and what Congress clearly wrote this statute is they put not everybody, but they put a very specific person in this unusual role as the substitute payer for a just compensation for the Cuban government, and it's the person who traffics in the property interest that was confiscated. Now, in this case, even one of the respondents, there's an argument that they went there before 2004. So this is not an argument that nobody gets compensation for this interest. But and if you have some amazing sugar that can still be used in 2027, well then that's something where you can traffic in that which was confiscated.
Magic
there
sugar.
Are plenty of interest, and I do want to say the single largest element of all
Infinity
of these
and beyond
claims, when I
sugar.
looked at them, are these forgiven debts or repudiated debts or destroyed accounts receivable because they expropriated the other U.S. company. I don't see how anybody traffics in any of those. So Congress wasn't trying to pass a statute that says we don't want anybody to go anywhere near Cuba, and we want to provide a trafficking remedy for everybody who has a claim against Cuba. It's a more limited statute, and this is the other thing, Justice Jackson. If you look at the statute, my friends want you to sort of say, this is the most punitive statute ever, so you should interpret it, every word in it, to be as punitive as possible. That's actually not the statute that Congress wrote. There are things like anybody who was there before gets a grace period. There's a 2-year statute of limitations, so if nobody sues you within 2 years of trafficking, there's an amount in controversy requirement.
Why doesn't that go to deterrence? The last thing the SG said was it's not remedial. That the point of it is to make this scheme be so that cruise lines in the future will not use property that has been confiscated by the Cuban government in this way.
So can I say 2 things in response
Yes.
to that? One is that everything I just said about the statute not being maximally punitive means that it's also not maximally deterrent. It's a balanced statute. There are provisions in there. Presumably it was a compromise. The other thing is, if you take a step back, this is at some level a statute about compensation, because what makes what Cuba did unlawful is not that they took U.S. nationals' property. It's that they did it without providing just compensation. So the whole theory of this statute is, I don't know whether we're ever going to get just compensation from Cuba, but if we can get substitute payers who actually traffic in the confiscated property, that's good enough. I'm sorry.
Thank you, counsel. Justice Thomas, Justice Alito, Justice Sotomayor, Justice Gorsuch, anything further?
Just critical to your whole case and the answers to everyone is the exact parsing of the definition of property. So you just want to walk through the definition of property, because you said to Justice Alito, and we're piecing together various parts of the statute, but I think it boils down to those words in the property definition, I think. And if so, can you just walk us through and summarize your position on that?
Sure. I mean, for me, it's most helpful to start with 682A1A.
Oh,
that says
thought we were
any
gonna do a-
person, and I'm going to skip over after the end of the 3-month period, any person that traffics in property which was confiscated. So then, it's a defined term in the statute, so of course, like any good textualist, I'm going to go to the definition of property in the statute, which is in sub 12. It's an 11A of the appendix to the blue brief. And then it says the term property means any property, and that seems to me almost the most important thing. But to me, what makes this kind of easy is then it says, including any leasehold interest. Okay, so I know that the concession's not exactly a leasehold interest, because a leasehold gives you control, and we desperately say they didn't have control of the docks, they just had a concession. But it's at least like
I'll
a leasehold,
respond in a
and then
moment.
it's time limited. And then I pop back to 682A1A, and I say, okay, who has the cause of
A1A,
action here?
Beachfront Avenue.
It's the U.S. national who owns the claim, not a claim, which, I mean, I know, like, you don't always get too excited about definite versus indefinite articles, but this would be a much better statute for the other side if it said instead of the. It says the claim, but here's the killer, to such property. And so the such property has to refer back to the property that was confiscated, and that isn't like the street address or the docks as facilities. That's the property that was confiscated, and that includes a leasehold, but when the leasehold's over, you're not going to be in a position to find somebody who trafficked in that which was confiscated.
Thank you.
That's all I got.
Barrett?
No.
Justice Jackson? Thank you, counsel.
Thank you, Your Honors.
Okay, real quick.
Rebuttal, Mr. Klinger?
I did my first semester, or my first year of law school at LSU. So my property class, my first semester, was a civil law property class. Essentially the same law that we studied, that you'd study in Cuba. So that was the property that I learned. So this is like my stuff, and you're not going to find many lawyers who've studied that.
Particularly if you don't have a certified claim, you're asserting the claim.
Especially not before they learned common law
You still
property.
need to show that there's ownership to it. And if someone else has a certified claim that is covering the same interests, that you don't have the claim. So Congress had to use the claim there. But in A3, it talks about liability arising from someone who traffics, and the liability is in relation to anyone who holds a claim. Same with A4. It talks about bringing an action on a claim. Second, Justice Alito's advice question isn't hypothetical. The Cruise Line Association was asked, as it appeared that suspension may be lifted for the private right of action, they're asked, do we have exposure here? And the answer wasn't, oh no, there may be some litigation risk, but 2005 on, you're fine. It was, oh my gosh, you have a tremendous amount of risk, and they gave us certain reasons that might be defensive.
He's talking about a
but
different time
the
period.
gist of it was
He's talking about
heartily that the
2019,
statute's
not
clear and in some way
2016.
relieves you of the obligation. And when the cruise
That's
lines
kinda-
were lobbying to keep the suspension.
Yeah, he's talking about 2019, not when they started
private
running
right of
cruises
action
again in
suspended,
2016.
They said, please, President Trump, don't implement the private right of
Yeah,
action
because
we're
we've
liable for
already
hundreds of
been
millions of dollars.
doing this since
Exactly what
2016 when
happened.
you
We've been
restarted letting
advised
us.
by their lawyers. We have the Clio memo
That is-
in the joint appendix.
He knows better.
And the 2005 issue didn't even feature, at least prominently. There's a lot that were mentioned. You can throw one of the, well, and then a third is, I just want to tie the foreign policy interest to the scope of the remedy here. I think that, I mean, kryptonite was a better example. I wish I'd used that, but this is designed by Congress to put property that had been seized off limits from trafficking. That's what fueled the communist regime. That's what was trying to be prohibited here, in addition to giving an incentive for Cuba to
In fairness,
make a remedy,
apparently
but I don't
nobody
think
else said it right,
that was
so he's
actually
getting away with it
expected.
because I'm sure he was sitting there like,
11th
are
Circuit's
they going to say it? Are they going to
approach
say it? Nobody said it? All right.
Almost as nothing is left of the statute in this regard. That it's not just a few
He knows he gets to talk
time-limited
last.
interests. It's leases. Almost all business leases over a 65-year period will have evaporated by now. It's life interests. Every day another interest holder dies, then that property is freed up for exploitation under the
You can finish your sentence.
freed up for exploitation under the 11th Circuit's view.
Thank you, counsel. The case is submitted.
Okay. Well, that was weird. All right, hold on. So they said the case is submitted, shut off the audio. There's a second case. Oh, there we go. I was like, that was weird. The second case is, it's about the same stuff. Whoops, sorry. But this time it's Exxon v. Cimex Cuba. They're actually suing the country of Cuba to recover the same thing, the stuff that was seized from them in 1960. And the question is, are they allowed to sue a sovereign government? Generally, the answer is no. And the question is, did this law, this Libertad law, give them a special exemption to go ahead and directly sue a government? That last case seemed to rely on the fact that no, they couldn't. They already seemed to assume that as they went through there. So this is going to be interesting.
Your argument next in case 24-699, ExxonMobil Corporation versus Coracion Cimex et al.
I know, I got the cases backwards on the video this morning.
Ms. Ratner?
Mr. Chief Justice, and may it please the court. If you read the Helms-Burton Act from front to back, you'll have one clear takeaway, and it's the one already mentioned this morning, that the 1996 Congress wanted to put crushing diplomatic and economic pressure on the Cuban government. That includes by abrogating the sovereign immunity of Cuban instrumentalities in claims brought under Title III of that act. Now, there's admittedly a high bar for abrogation, but this court has said again and again that Congress doesn't need to use magic words to get there. It just needs to make its intent clear through what Kurtz called the sum total of its work. And it did that here. Let me start with the most important piece, Section 6082A. Congress created a cause of action and expressly applied that cause of action to foreign instrumentalities. That's a standard route to abrogation that this court has recognized in Kurtz, Kimmel, Hibbs, and Financial Oversight and Management Board. Then Congress did three things to confirm that that was its intent. First, we know with absolute certainty that it wanted claims and judgments against Cuban instrumentalities because it repeatedly discusses them, including at 6082A7, C2, and D. That was up for debate in Kimmel and Kurtz. It's not up for debate here. Second, Congress emphasized that it wanted fully effective remedies in U.S. courts, including against governments. That's 60818 and 11. And third, at the same time it authorized suits against Cuban instrumentalities, Congress also codified an incredibly restrictive embargo cutting off commerce between the United States and Cuba. That combination makes no sense if Congress had intended to rely on FSIA exceptions that depend on commercial activity. I welcome the court's questions.
Are we to treat the assertion of sovereignty the same here as we did in Kurtz?
Well, Justice Thomas, to the extent you mean, is there a different test for foreign sovereigns or other kinds of sovereigns? We have not argued for a lower test. I think arguably the sovereign immunity asserted in suits involving states and the federal government may be on even stronger footing than the sovereign immunity of foreign governments, because when it comes to foreign governments, that's entirely a matter of comedy and grace. But our point is simply that foreign governments shouldn't be better off than all of the other types of sovereigns, states, the federal government, Indian tribes, and territories in the case that...
If we accept your argument, what would the interaction of Title III and the FSIA look like?
So there are effectively two ways to harmonize those two statutes here. One is the way that we're advancing, which is the FSIA is a general rule, and the Helms-Burton Act is an additional specific abrogation. The other way of harmonizing is what respondents have said, which is the Helms-Burton Act provides the cause of action and the FSIA provides any abrogation of immunity. And our point is simply, it is not plausible to believe that Congress intended the latter rather than the former. And we know that for several reasons. I think the fact that it simultaneously enacted the embargo is a pretty glaring one. The court often says Congress doesn't enact meaningless statutes. And the notion that it would circulate these claims over to a separate immunity regime that depends on commercial activity with the United States, while simultaneously banning commercial activity with the United States, is a pretty glaring neon sign.
Could we stop at your first point? Because what you're arguing is that the statute here impliedly reversed FISA's application, correct?
So no, Justice Sotomayor, I don't think that's right. I'm happy to, I think we reached the level of clarity necessary for that, but that's not how this court talks.
Well, let's go to that. I
Okay.
mean, we do know that in Kurtz, there was no statute. It was just how to read this statute, correct?
That statute in conjunction with background principles that
Background
required a clear
principles, but
statement.
not another statute. The idea of irreconcilable conflict was present in Kurtz itself. And the court explained that if Congress enacts a cause of action against a governmental agency, and there is no way to bring that claim, those were Kurtz's words, against any government agency, then the cause of action itself must abrogate sovereign immunity. But that's not the case here. In fact, you've brought a case, a claim that still survives against Cimex. And as I'm reading the record, there's been so much investment in Cuba, even before the current president. Cimex itself operates Western unions on confiscated property. There's over 100 companies since 2001 that have exported products to Cuba. There's ongoing agricultural and other exports. So this isn't a dead letter if we impose sovereign immunity principles here. That's very different than Kurtz, isn't it?
Justice Sotomayor, let me say a couple things about that. First is, we don't know if it's a dead letter. Nobody has actually successfully made a claim through yet. Our claim, after 7 years with one of the largest and most diverse claim, has not yet made it through. But more importantly, I don't think Kurtz says you need to have a dead letter. What Kurtz says is, if Congress defines a claim, specifically applies it against a government entity, and applying immunity in that circumstance would negate claims Congress wanted, then we think that's a pretty good sign that that statute itself abrogates immunity.
You're going in a circle, counsel. You're trying to read an intent into Congress by saying they wanted a bigger claim than the one I could have. But if a claim is still possible, what that means is that the two statutes, FISA and Title III, can be read harmoniously, which is our charge, not to implicate repeal.
Justice Sotomayor, so let me address the Kurtz point, and I do want to go back to why this is not an implied repeal. On Kurtz, again, I think it is unequivocal that this would effectively negate many, maybe most, maybe all of the claims that Congress authorized. Kurtz did not rest on a notion that 100% of the claims could never come through.
Well, I think it sort of did, Ms. Ratner. I mean, in Kurtz, in FMOMB, it was just true that if read one way, there was going to be a cause of action without any ability to bring the suit. And that was what, in all those cases, seemed absurd. That why would there be a cause of action if there's no way to bring a suit? You give with one hand, you take away with the other. But in this case, it's not, for the reason that Justice Sotomayor suggested. The FSIA is this background law that and it's trans-substantive. It assumes that there are going to be other causes of action all around, but that it is the thing that it tells you, for purposes of all those causes of action, When are you immune and when are you not immune?
Thanks,
And
penalty
here,
high.
the FSIA sets up a series of tests, when you're immune, when you're not immune. And so why shouldn't we just take that as like, okay, it's the FSIA that is the relevant statute here. The fact that there's causes of action, of course there's a cause of action in Article 3, as well as in many other statutes, but we don't take that to be, we don't look to those causes of action for purposes of deciding jurisdictional immunity for foreign agencies.
So, Justice Kagan, let me try to unpack two things from there. First, I don't want to give up on the Kurtz point, because I do think in Kimmel, it was not 100% superfluous. The state defendants came in and argued there are state statutory waiver schemes, so the existence of a cause of action will not negate all claims against states. This court rejected that out of hand. That's page 75 of Kimmel, on which Kurtz was based. But moving to the FSIA, the notion that the FSIA is sort of the comprehensive scheme here and something, Justice Sotomayor, that you'd have to impliedly repeal, I think is inconsistent with the court's 2009 decision in Beatty. And there, this is involving the particular terrorism provisions as they relate to the Republic of Iraq. And there, the situation was reversed. It was Congress allowing the president to remove a waiver of sovereign immunity. But the court there said, this is a specific targeted rule at a moment in time and a particular actor, and it doesn't need to reference the FSIA to
So I guess that
supplement it.
seems right, that there could be statutes which don't need, if this statute gave you a cause of action and gave you jurisdiction under 1331, which it might, and which also said, there's an abrogation of immunity, then I am totally with you. It doesn't matter that the FSIA exists. But in fact, this statute does not do the last thing. So in that world, it seems as though, Congress knows that there's an FSIA around which provides the jurisdictional immunity rules. And so if Congress doesn't substitute in another statute.
FSIA says you can't sue another country except in these particular circumstances, or if another law says you can get around the FSIA.
Justice Kagan, I think there are two problems with that. One is doctrinal and one is statutory. The doctrinal problem is that just gets us back to a magic words requirement that the court has refused to apply.
No magic words. They can abrogate immunity in any words they want to, but they have to abrogate immunity to replace the FSIA.
And that is exactly the question here. Has Congress clearly abrogated immunity here? And we think, through the sum total of its work, the answer is yes.
But a cause of action doesn't abrogate immunity. It just doesn't. There are causes of action all over the place that rely on the FSIA as providing the jurisdictional rules.
There are extremely few causes of action that expressly apply to foreign governments, foreign agencies, and instrumentalities. By our count, our petition has them at page 30. There's one about chemical weapons regulations, one about nuclear
Lavender, a
weapons
magic
regulations,
words requirement
and one about
means if
certain
you don't
trafficking
say
crimes.
X,
So
Y,
that
Z,
is, I
it
think,
doesn't
the
count.
biggest universe.
Sometimes that's the rule,
Relying
sometimes
so
it
much
isn't.
on Kurtz and Kimmel and so forth, where it was just a broad cause of action. So you can't kind of have it both ways there.
Justice Kagan, I am not trying to have it both ways. What I am relying on from Kurtz and Kimmel is the notion that when Congress expressly calls out this group of defendants, that's when we think maybe it's saying something on abrogation as well.
How can that be squared with the language in the FSIA that says this is the exclusive statute that tells you when you abrogate? I mean, the problem, I think, and this is the point that Justice Sotomayor was raising, is that unless Title III speaks to abrogation, I don't know how you overcome the statute that says abrogation for foreign governments, look here and apply this rule. And you say, I think, from your original statement, well, you can overcome that or ignore that because, in this case, Congress created a cause of action, repeatedly indicated that it wanted these kinds of suits to be brought against the government. It wanted fully effective remedies in court, and it wanted embargoes. I understood those to be the kind of thrust of your argument. But I think it has two problems. One is that it didn't speak directly to abrogation, and we know that cause of action and abrogation are two different things, in light of a statute that says, look over here when you're looking for the abrogation answer. So that's one problem. And then the other problem is we had a clear statement rule in the world of jurisdiction and abrogation. So if Congress was relying on the kinds of things you're talking about, I don't understand how they even thought that that could possibly be enough to displace the statement in the FSIA that says this is how you abrogate.
Justice Jackson, this would unequivocally pass the clear statement rule as applied to any other of the various sovereigns I mentioned. And then the question is, are foreign sovereigns better off because their immunity
No, the question
put in a statute?
is, does the Foreign Sovereign Immunity Act apply to the other sovereigns you mentioned? The answer is no. So when we're in the world of foreign sovereigns, we have a special rule that Congress has carved out that tells us this is how you determine whether abrogation occurs for foreign sovereigns. And the only question here is whether what Congress does in Title III is enough to displace that rule, as opposed to we look at this and we think Congress was setting up a cause of action in Title III and relying on its long-established, pre-existing rule for how you abrogate.
Justice Jackson, what Congress did here would unequivocally be enough for any other foreign sovereign. And so then the question is, does the existence of the FSIA...
For any other foreign sovereign?
Excuse me, any other governmental sovereign.
Right, and so
then
my
the
answer
question
is it enough for any other foreign sovereign?
Does the existence of the FSIA mean that we need an even clearer statement, a clear statement above the clear statement? And
No,
and
but the
just to go
question
back-
is, can you harmonize the two statutes? I keep going back to that point. Look at your Iraq question, okay? There, the court was looking at the FSIA and the presidential provision, the EWSSA. And what we read there was the FSIA has a default waiver of Iraq's sovereign immunity. The EWSSA permits the president, quote, to make inapplicable with respect to Iraq any provision of law that applies to countries that have supported terrorism. The two are addressing exactly the same thing, and they're saying you can do one. The president can do one. So that was clear. We were trying to harmonize those two statutes and said, yes, the president has that power. Here, the way to harmonize the two statutes is to say it applies only to commercial exceptions permitted by the FSIA. And, as in Kurtz, or unlike as in Kurtz, the two statutes, if harmonized in that way, still make this operative.
Justice
Still
Sotomayor,
permits suits against foreign sovereign entities who engage in commercial activity.
that is a way to harmonize them. I don't think it is a plausible one. The other way to harmonize them
well, we go
is
back
by,
to what's plausible. Here,
Well-
you have a suit that has survived a motion to dismiss. We know Western Union has business there. The suit is against an entity that's doing business with Western Union. There are ways, and there is money flowing into, even with the embargo, as extreme as it is at the moment, there is still many commercial investments going on in Cuba.
so Justice Sotomayor, again, the question we're looking at is 1996, when Congress codifies an extremely restrictive embargo in 6032H. It adds provisions preventing circumvention in 6040, and it allows extremely few exceptions for humanitarian links. And the question is, should the statute be read to allow causes of action only in the rare circumstances where they can find a connection to one of those humanitarian links? I think that is an implausible way to harmonize the statutes.
Thank you, counsel. Justice Thomas? Justice Alito?
If Congress didn't think that the FSIA applied to Helms-Burton actions, why would it have amended the FSIA's execution immunity rules for those cases?
So, Justice Alito, I think 1611C is a little hard to understand. It can either be read as a We don't think there's a conflict here, but at belt and suspenders, we want to avoid anyone thinking there is. Or it can be read as suggestive that with respect to execution immunity, the FSIA provisions apply. I think it has to be the former way because elsewhere, Congress expressly and selectively incorporates FSIA provisions, including in 6082C2. And I think in combination of that and C1, where Congress says we want to apply only the provisions of Title 28 that apply in Section 1331 cases, which does not include the FSIA. When you read those in combination, I think that you can only read 1611C as kind of a belt and suspenders provision.
Thank you.
Lavender, there will be a lot of friends of the court who
Your
will have
point is
submitted
statutory
briefs
history, so
on
do
things,
I.
but
And
the government
I
might
take
actually
seriously the
speak as a
fact
friend of the court.
that the original
Every once in a while, somebody
both
else will
Senate
speak as a
and
friend
House
too.
bills
That's
here
rare.
under Title III included a waiver of the FSIA. And so it's not clear to me that when Congress took it out, why we would be putting that waiver back in.
So, Justice Sotomayor, if you really dig in on the legislative history, I think it becomes clear that Congress did not change its mind on whether to abrogate. It changed its mind on whose immunity to abrogate. So in February of 95, the
So
bill
why
is-
didn't it say that directly? I know,
Well-
but that's assuming that
Watch that.
it's clear that it took out
probably
the
would've
Cuban
too, but-
government and substituted subsidiaries and agencies, correct? That's what
That's
you're
correct.
relying on.
Correct.
But that still begs the question. The DOJ had made very clear that abrogating sovereign immunity of the government and its instrumentalities would be a violation of international law, correct?
That's correct.
All right? So it took out any suggestion that it was abrogating sovereign immunity, dropped it from both bills, dropped the federal government but kept foreign instrumentalities. But from that history, why would I assume that it was intending to abrogate immunity?
Justice Sotomayor, that is not the correct history. The history is February of 95, the original bill abrogates immunity under the FSIA for governments themselves. Then there's an outcry about various aspects of the bill. August of 95, they take out that immunity provision
Filibuster.
and they add in this specific reference to claims against agencies and instrumentalities.
But that
and
doesn't
then
make
after
any
that,
sense to take it out, to take out the waiver of FSIA, because FSIA goes both to the government and to the agents and instrumentalities, and the government's letter was complaining about all of this
This court
being
doesn't really
in
care about
violation
legislative history.
of international law.
So, Justice Sotomayor, two quick things. One is the FSIA provision, Section 1605, although it does cover both foreign states and agencies and instrumentalities, there's no specific existing provisions carving out just agencies and instrumentalities. So although I could write that language for you, Congress did not have a copy and paste job once it got rid of foreign states. And second, if you are looking at that legislative history, I do think you have to look at the fact that the State Department, 2 months after this amendment, continued to say, well, now it applies to agencies and instrumentalities, sure, but it is still going beyond the FSIA. That likely ground the bill to a halt in the fall until Cuba shot 2 planes out of the sky, and all of a sudden supermajorities of Congress passed, and the president signed this law within 17 days.
Justice Kagan? Justice Gorsuch? Kavanaugh?
The other side says that you need to take account of the provision that allows the president to essentially have an on-off switch here. And one of the amicus briefs talks about that at some length. In other words, it would be quite extraordinary for Congress to allow billions of dollars, tens of billions, hundreds of billions of dollars to be decided by an on-off switch just at the president. There's really no constraints on the president's ability to do that in the statutory language. I think national interests.
That amicus brief was written by one of my favorite authors,
transition
Erwin
to
Chemerinsky.
democracy in Cuba. And they say for that reason, we shouldn't assume Congress intended to give that huge power to the president, so therefore choose the narrower second option as you first described them, I think, rather
don't
than
know
the
where
first
Merchant
one. You
Whiskey
want to
was.
respond to that?
Yes, so Justice Kavanaugh, I think it's exactly the opposite, which is the whole reason we needed this presidential fail-safe is because claims against the Cuban government could be so substantial that they would interfere with its progress to democracy. And that's why there are 4 separate suspension provisions throughout the statute that give ways to toggle on and off claims, including claims and judgments against the Cuban government specifically, as necessary to help diplomatically toward a democratic Cuba. And there's no reason to include those if what we're talking about is a couple edge cases that are linked on to some humanitarian food exports. Then we don't have the wave of claims against Cuban governments that would cause a need for that kind of presidential backstop.
So you don't think there's some kind of clear statement required in connection with that? That's what they, I think, are saying on page 47, and then the amicus brief also.
I
In other
don't
words, we'd expect Congress to speak really clearly if they're going to give the president so much power, and they
I mean, first, I think Congress probably thought it was putting on more constraints. In fact, if you are
National
looking at the
interest?
legislative history, the conference report said, we don't think in good faith the president could actually impose this suspension, but leaving that to the side,
well,
again.
it was in place then from 96 to 2017, right?
It sure was. I think the president and Congress probably had differing views, but what they didn't have differing views on was the importance of this wave of claims against Cuban instrumentalities, and that's why you need to have 4 different suspension provisions to toggle on and off for all the diplomatic circumstances. You just don't need that if we're talking about a couple edge cases getting through.
Thank you.
Justice Barrett?
Ms. Reiner, do you think that the Libertad Act abrogates sovereign immunity for agencies and instrumentalities of countries other than Cuba?
So we've stated in our brief that the answer is probably yes, if that question ever came up to the court. We have sort of a host of statutory indicia. Most of them would apply to everyone. Some apply only to Cuban instrumentalities. I think there's probably enough that Congress would have said other nations who have instrumentalities that are knowingly and intentionally trafficking in the confiscated property, that they'd be on the hook too. But we don't think, and the government doesn't think, the court needs to answer that question, given that some of the indicia are Cuba-specific, and we've never seen a non-Cuba.
Well, I mean, I think the thing that's hard for you is that, you have a lot in the statute that points to Cuba, and that makes Cuba an exception. I think it's a different question, a slightly different question, whether the statute is clear enough if you're talking about other sovereigns. And so even though I agree with you and the government that we wouldn't have to answer that question directly, I think it lurks in the background of deciding whether this waiver or this abrogation is clear enough.
Yeah, Justice Barrett, I don't think the 1996 Congress would have had any qualms if other entities that were, again, we're talking about instrumentalities, so essentially state-controlled companies, were partnering with Cuban state-controlled companies, knowingly and intentionally trafficking, that they would be swept in just as private parties are. But again, if the court does have qualms about that, it's a purely hypothetical circumstance at this point, so we don't see any need to weigh in on it.
Justice Jackson?
So it seems to me that the thrust of your argument is that we should look at this language in Title III and know that it is clear that Congress meant to allow these claims and judgments to go forward because Congress wanted these claims to proceed. The political and foreign policy circumstances were such that, it was sort of punishing Cuba for having confiscated people's property. And I see that. But how do you respond to all of the evidence that we have that indicates that that really wasn't, in other words, the claims process really wasn't the primary thrust of this statute? This dovetails with what we were talking about in the earlier case, that when we see that what Congress was trying to do was to isolate Cuba economically by deterring third-party investment, then maybe when it set up this cause of action, it really was like, I'm just going to let the regular rules operate as to whether or not you can actually bring a claim, because my focus, I'm impersonating Congress now, my focus is on this third-party investment problem that I'm trying to solve. You say, yes, but you set up a cause of action, so that must have meant that they also intended to abrogate sovereign immunity, and I guess I don't necessarily see why that's the case.
So, Justice Jackson, the thrust of our argument is not just that Congress set up a cause of action. It is that this is woven into the architecture of the statute. When Congress talks about who would be defendants, well, the only defendants it calls out by name are foreign instrumentalities. When it talks about specific rules for claims, the only particular claims it talks about are claims against Cuban instrumentalities.
Right, so it appreciated that claims could happen. I'm not faulting you or saying that that's not in there. What I'm asking you is whether it intended for those claims to happen under the circumstances that the FSIA would allow.
And I think the answer, the two best pieces of evidence on that for why the answer is no, one is the embargo we've already talked about, especially the embargo as codified in 1996, and two is section 6032, section 6082C, which says, apply the provisions of Title 28 that apply in Section 1331 actions, general federal question actions. That does not include the FSIA.
All right, let me ask you one more, and then I'm done with this part. How does allowing this flood of claims to come in advance what I see as Congress's primary purpose? I think you get a little bit more mileage out of it if you're saying they absolutely intended to abrogate sovereign immunity with this cause of action, notwithstanding the existence of the FSIA, and they're not saying anything about that, because we know that they were trying to deter third-party investment, and somehow this is going to help that. So help me to figure out how allowing this flood of claims is actually aimed at furthering Congress's primary purpose for this statute.
Because the primary purpose was not just third-party traffickers. The other primary purpose, probably the primary purpose, was the Cuban government itself as the key culprit here. And so preserving FSIA immunity would give a Cuban instrumentality a pass when a comparable private company would be on the hook for a trafficking claim, and the Cuban company would get a pass by dint of its relationship to the Cuban government. That is hard to square.
Maybe. I mean, there's foreign policy implications. The U.S. government is actually punishing
But
Cuba.
Justice Jackson, this is a statute that a couple provisions earlier has accused Cuba of, quote, cold-blooded murder. It is a couple provisions before that has said residential property is off limits unless you're associated with the Cuban government. Then we're going after your house, too.
And your point is that the statute is authorizing private individuals like Exxon to be like an AG to punish the Cuban government for that.
No,
conduct.
Justice Jackson, my point it is implausible that Congress would have wanted a Cuban company to fare better than a private trafficker, given all of the other statutory signals.
Thank you.
Thank you, counsel. Mr. Gannon?
Mr. Chief Justice, and may it please the court. Taken together, multiple provisions of the Libertad Act clearly show that Congress abrogated the jurisdictional immunity of Cuban agencies and instrumentalities without regard to the Foreign Sovereign Immunities Act. Apart from the definition of person, other provisions clearly contemplate that Cuban agencies and instrumentalities will be defendants against whom judgments may be obtained. But two more provisions particularly establish that the FSIA does not generally apply to Title III suits. Section 6082C1 makes it clear that such suits are brought under 28 U.S.C. 1331 rather than the neighboring section that supplies jurisdiction for suits under the FSIA itself. And then 6082C2 affirmatively brings in a particular section of the otherwise ousted FSIA. The decision below would effectively negate suits that Congress authorized, thereby compromising a mechanism that Congress and the executive have concluded will promote U.S. and national interests and a transition to democracy in Cuba. This court should reverse that decision. I welcome its questions.
Should we treat the assertion of sovereign immunity here any different from the assertion of sovereign immunity in Kurtz?
I think that we take comfort from the fact that we have a lot of additional provisions. I'm not quibbling at all with the idea that there still needs to be a clear statement. And to the extent that Justice Jackson was asking questions about the fact that we have a statute here that makes this different, we're not just talking about sort of a common law background, we're trying to reconcile two different statutory schemes, I would say the point that I just made makes it clear that Congress was displacing the FSIA as the background rule here when it said that this is an action that's going to arise under 1331. The jurisdictional provisions of the jurisdictional immunity of the FSIA goes through Section 1330. 1330 says that jurisdiction exists when an exception to the FSIA has been satisfied, and here Congress said that's not the statute that governs this action. It said this is a federal question jurisdiction.
So do you think that these two statutes can be reconciled?
I think that as my friend was just saying, I wouldn't reconcile them by saying that you need to go through both gates. I understand that that's a normal thing to do when you're looking at two different statutory schemes. I think Congress has already made the decision and said, we want this not to be an FSIA suit, and they did not want this to be a Swiss cheese situation where there would have to be some incidental overlap that would allow you to get through one of the commercial activities exception here.
I'm sorry, Ken, answer the question. Could you go through both gates?
I think
is it impossible to go through both gates?
I think in the vast majority of suits, it probably is going to be impossible.
I didn't ask that.
There
are still
I am not going to say that there will never be a suit where the plaintiff could satisfy the commercial activities exception, but I think that that's a gross mismatch between what Congress was targeting here, which is trafficking in all of this expropriated property, especially when the Cuban governmental entities are the main the main culprits and beneficiaries of that trafficking conduct, which Congress wanted to.
The main culprit was the Cuban government, yet Congress dropped the Cuban government as one of the potential defendants. So I don't see how there was congruity there. Two amicus briefs, the Foreign Sovereign Immunities scholars and the Foreign International Law scholars, raised the Charming Betsy interpretation, canon of interpretation. We know Charming Betsy was at the founding, and we know that Congress wanted to push the boundaries of international law with Title III. But Charming Betsy cautions us to try to construe statutes not to violate international law. Here, not only is it pushing it to a private cause of action against the Cuban government and its subsidiaries, Justice Barrett has asked the Petitioner's Council whether they could also sue other countries' agencies and instrumentalities, and she said yes.
Venezuela comes in.
What's your position on that?
Well, I'm happy to start with the third country's question, but I also want to get back to talk about the customary international law point that you were making about Charming Betsy. And with respect to third countries, footnote 5 in our brief doesn't take a position on this.
Isn't it the logic of your position? If you're saying that it abrogated the FSIA, why would that abrogation, because it doesn't say it abrogates sovereign immunity with respect just to Cuba.
I think that several of the provisions are Cuba-specific, the ones that specific.
Several are, but not all of them.
I agree with that, Justice Sotomayor, and I think that it is clearer that there is an abrogation with respect to Cuban agencies and instrumentalities, and I think that that would be enough for the court in this case. But if you think that it's all or nothing, then I would make 2 points that would mitigate the potential risks associated with that. First, to our knowledge, there's not a single pending Title III case that brings any claims against third country agencies and instrumentalities. And second,
once we say it's okay, even if we reserve the question,
they make, and second,
you know that we're inviting that litigation.
And my second point is, to the extent that it looks like that's going to be any sort of problem, then the president has the suspension power, and he could suspend or partially
the president is the one who wants to bring these.
Title III actions if he thought that that was going to create foreign policy problems. And that also was part of my answer to your question about the customary international law point in Charming Betsy, which is that the administration, the executive branch, was very concerned about exactly those types of things when this bill was being debated in 1995 and 1996. And the State Department letter that my friends on the other side quote specifically said that the suits against agencies and instrumentalities would go far beyond current exemptions in the FSIA. The executive branch was concerned about this, and I think Congress's response to that was to say, we are going to exercise our power to go beyond what the FSIA currently allows. But if you were to adopt the respondent's reading here, then that would not be the case, because it would not be able to go beyond the FSIA if they also had to comply with the FSIA. And the one change that I think Congress made after that point in the legislative development that is relevant to this is that at the executive branch's request, they granted the president the suspension power. And the suspension power is a way for the president to help manage whether he thinks that the risk to foreign policy, offending foreign sovereigns, whether we're going beyond what customary international law allows, is worth it with respect to the U.S. national interests and expediting a transition to democracy in Cuba.
Which way does the suspension power cut here? I'm trying to figure that out, because your rhetoric and petitioner's counsel is Congress really wanted to allow these suits and not have them subject to the gatekeeping of the FSIA. And yet, Congress gave the president unlimited power to say no, almost unlimited power to say no, which then happened for the next 23 years. Yeah. And that's really just based on national interest. Basically, it's completely up to the president.
I mean, to be clear, Justice Kavanaugh, I do think it's quite clear Congress gave this suspension power to the president with those qualifications, and so I don't think that there's something that we need to sort of decline to think that Congress gave him that power.
No, I know.
Secondly, I would say that...
Let me just finish. I know they gave him that power, but how does, and this is my question, just how should that affect how we think about the FSIA? Because it's not just, oh, Congress wanted these suits tomorrow.
Well, I think it suggests that they recognized that they were going past what the FSIA would otherwise allow, and that therefore there was a need to have this extra potential governor on the speed of the process, but they were very clear that they wanted it not just to be U.S. national interest. They actually changed the phrasing of what the executive branch requested, as explained in the conference report, and some of the floor statements associated with the adoption of the final bill, to say that they wanted it to be U.S. national interest, and it had to promote expedition of a transition to democracy.
That's 100% in the discretion of the president. 100%.
That is his determination to make. He reports it to Congress, and that's the power that he has to suspend this. But I think that
so this transitions us back. The statute, when you put the presidential suspension part into it, really transitions back to the pre-FSIA. It's just up to the president.
Well, I mean, I think
which might be the right answer here. I'm not saying it's not the right answer.
I think what Congress has done is Congress has actually sort of created the default rule here, which is that these causes of action will proceed. These will be appropriate defendants, and the FSIA is not a separate.
It's totally up to the president whether these claims can proceed.
The president ultimately has the ability.
Isn't that right?
Yes, ultimately has the ability to decide that, because if he is doing it for the purposes that the Libertad Act was intended to promote, which is encouraging a transition to Cuba. To the extent that these types of trafficking lawsuits are a problem,
I'm sure that's what it says.
if it's because they're
think that's
lawsuits against
judicially
third
reviewable?
countries.
I mean, this is getting in the weeds, but since you're putting so much weight on that second clause, do you think a court could review that? His determination that it was
I would not expect that to be judicially reviewable. It's something that he needs to report to Congress. I think that there's political accountability associated with that, but that Congress recognized that this is going to be a situation that had been evolving for decades, that had taken them decades to get from the Foreign Claims Settlement Commission to this, but they wanted this to go as fast as it could, with the president able to make judgments according to the way circumstances developed.
Thank you, counsel. Justice Thomas, anything further?
What are the practical implications of the interesting question in this case? Unless Cuban instrumentalities have property in the United States against which a judgment could be executed, what difference does all of this make as a practical matter?
What's the point?
I think that's an excellent question, Justice Alito. And as a practical matter, that sort of obviates the need to even answer the question about 1610 and 1611C. If Cimex doesn't have any assets in the United States,
Unless
then,
what you're after
then
is
the
Venezuela.
execution immunity question that you were asking sort of drops out. But that doesn't mean that there isn't value to having a judgment, and there's nothing anomalous about having the exceptions to attach execution and attachment immunity be narrower than the exception to jurisdictional immunity. The court observed that in NML Capital, and in some suits it literally is the case that the plaintiff simply can't collect on a judgment that it got consistent with an exception to jurisdictional immunity in the FSIA unless there's a waiver of the defendant. But that doesn't mean that there isn't value to having a judgment. It can be taken to courts in other countries to the extent that that this goes beyond what customary international law allows. Those other countries may be less likely to enforce, depending upon what the situation is. But I think that a company like Exxon that had tens of $70 million expropriated in 1960, and you see a lot of suits that come here occasionally where long-lived corporations and others have investments that they want to vindicate. They get a judgment. It may take decades for them to find property in an appropriate case where they can try to attach, but that doesn't mean that they don't think that there's some value beyond just having the certified claim from the foreign claims settlement.
Perhaps I should have asked this of Ms. Ratner, and she can address
those
it or
assets
not
will
if she
suddenly
chooses when she gets up for
range.
rebuttal. But I assume Exxon has some financial reason for doing this, and it's kind of beyond me what the value of this judgment is going to be. If it can't be executed in the United States, which seems likely, and its value is dependent on registering it in a foreign country and trying to execute it there when the Helms-Burton Act goes beyond international law, that really seems like a long shot, but I'm probably missing something.
I mean, it might be a long shot, but as I said, that's not at all anomalous under the FSIA. The way it is designed, it is often the case that somebody can get a judgment, and there is literally not an applicable exception to execution immunity that is satisfied merely because they already had gotten through the gate of jurisdictional immunity.
Thank you, Counsel.
Do you see 6082C as a jurisdictional provision?
Yes, I think that it points us to 1331 as the basis for jurisdiction.
But it doesn't. It says procedure. But this section is labeled procedural requirements,
since like Friday.
not jurisdictional. And the first subsection states that, quote, the rules of the courts of the U.S. apply to actions under this subsection to the same extent as such provisions and rules apply to any other action brought under Section 1331. So it's only talking about procedures. It's not talking about jurisdiction.
I think what it is saying is that all the provisions of Title 28 apply as if it is a federal question jurisdiction action like any other, and it uses the word other. And I think there's no way to read the word other there without making it say that this too is an action under 1331. Which means that this is not an FSIA suit under 1330. It's a federal question jurisdiction suit. There's also a separate, amount in controversy.
So we're still back to the original question: was the intent to repeal the FSIA? But that doesn't tell us that that was its intent.
I think because it's pointing to the jurisdictional provision of the FSIA.
No, it's pointing to procedural requirements of 1331.
But I think that reads out the word other. If you wanted to just say, we're going to treat this as if it is a 1331 action and use those procedures. We're going to borrow those the way it borrows other provisions from the FSIA. The very next subsection borrows its service of process rules, says use the rules, the service shall be made in accordance with Section 1608. They feel like they have to go grab a provision of the FSIA and pull it in and make it applicable. Here they said Title 28's rules apply here, like it's a 1331 suit. Like other 1331 suits. It doesn't say it's like it's a 1331 suit. It says it is another 1331 suit. And so I think that the only way to read that is if it's under 1331, it's not under 1330. They could have said 1330 or 1331. They could have said, depending on which defendant you have, if it's against a foreign sovereign, you would want it to be a 1330 suit. If it's against if it's against the cruise ships from the first case this morning, it's a federal question jurisdiction case. They didn't say that. They said it's 1331. And I think that the combination of these two provisions back to back, I take the point that the heading is procedural requirements, but that they're telling us building block things about the case, which is where do you get jurisdiction and how do you get service of process and hence personal jurisdiction. And so I do think that that shows that Congress was making the jurisdictional decision here, not just the liability creating decision, as Justice Kagan was previously asking.
Justice Kagan?
Well, I don't know. I mean, it seems to me you're asking us to do something very unusual here, which is to take a statute which does create a cause of action and a cause of action directly against foreign sovereigns, but to say that just because you've created a cause of action against foreign sovereigns, you're also abrogating immunity when you know that there's a Foreign Sovereign Immunities Act that is in charge of the immunity question, if you will. And it raises the question, you know, this is not a magic words test. It's like it could have done it in 1,000 different ways, but why didn't, rather than this very peculiar, you know, reference to 1331, which it's pretty unclear what it means, but why didn't Congress just say, like, we're displacing the FSIA with respect to this, or we're abrogating sovereign immunity, or just give some indication that that's what it meant to do, other than create a cause of action, which is a completely different question in the foreign sovereign immunity context.
I think that it did both. I mean, I just have to go back to what I said in my intro, what I just said in response to Justice Sotomayor. I think the only way to read 6082 C1 and C2 is to say that Congress here was speaking to questions of subject matter and personal jurisdiction with respect to foreign sovereigns, and that's the reason. I mean, if they wanted it to just be about other defendants, like the cruise lines, then they don't need to be.
So you're really saying it really hinges on those two little.
Those are the best indications we have that Congress is actually talking about it in the jurisdictional
sense. Yeah, so you're
sense.
not making a
but
point
we have
about, like,
all the other confirmatory provisions that my friend is relying on.
But you're not saying, oh, you know, like Kurtz definitely controls this because whenever you have a cause of action against a government, that answers your question. You're not saying that.
That is correct. I think we're asking for Kurtz plus. We think that the cause of action language. I don't want to minimize the importance of it. I think that the fact that the 1996 Congress used the same words that were able to waive federal sovereign immunity when they were talking about foreign instrumentalities and agencies. I think that is a compelling indication. But I think here it is important that we also have specific references to Cuban government agencies and instrumentalities all over the statute, and we have these provisions talking about what I'm calling an ouster of the jurisdictional portion of the FSIA.
If I could take you back to Justice Alito's question, and let's assume that I think that this execution immunity provisions in the FSIA really continue, you know, that there's no reason to think that they didn't continue on. And indeed, the fact that this statute amended them a little bit made it clear that Congress thought that they were going to continue. So then the point is then what you're asking us to do is to read the statute in a highly unusual way in order to abrogate sovereign immunity in cases in which, even putting aside the practical issues that Justice Alito was talking about, there are legal bars to collecting on your judgment against a foreign sovereign. So, like, why would Congress have done that?
I mean, you could ask the same thing with respect to other parts of the FSIA's immunity exceptions that aren't echoed in the attachment exceptions. And as the court said in NML Capital, it's a smaller set of exceptions for execution and attachment immunity than it is for jurisdictional immunity. And since then, the mismatch has actually grown. 1605 capital B, a new provision that Congress added in 2016, literally has no parallel in execution immunity. And so you have a waiver of jurisdictional immunity with respect to acts of international terror in the United States, and there's no corresponding waiver on attachment and execution immunity. And
yeah,
so
I mean, I guess one aspect of this is if sort of the thrust of the argument, and I know, you know, you're trying to hook it into these technical provisions, but if a thrust of the argument is Congress was really concerned about this problem and it really wanted to go after these agencies and instrumentalities because weren't they the ultimate bad guys here? I mean, if that's really what Congress was trying to do, it proceeded in a very odd fashion, because you're not going to get anything from them anyway, given that the execution immunity
They were going
exists.
after Cuba.
But take out
Where
the
are you gonna get the
execution
money?
immunity. There's still going to be
Well,
the
you
basic.
can take it out. That's
Well, no,
that was the question.
Well, no, but my point, Justice Kagan, was going to be back to what you alluded to, I thought, as the practical considerations that Justice Alito raised, which is that Congress knew there were not going to be very many Cuban assets in the United States anyway. Now, I mean, we have some blocked assets.
But
the federal
again, it's
government
not
has been
just the
holding for
practical thing
decades,
that
and
I'm
maybe.
saying. What Congress did not do was to touch executive immunity, execution immunity provisions that we're putting aside the practical concerns. We're going to prevent, as a legal matter, these agencies from having to cough up.
I think that 1611C is ambiguous about whether they were displacing 1610 or not. I think, as my friend pointed out, notwithstanding clauses often create this type of ambiguity, whether they're going to be, whether there's a negative implication or whether they're just belt and suspenders.
I don't buy that one.
And so we haven't taken a position on that. But as I'm saying, I think that it is quite common for there to be a mismatch between these two types of provisions. And I don't think when Congress was saying that it wanted these types of lawsuits to proceed and they wanted them to be a tool for foreign policy, that even if at the end of the day there wasn't going to be collection against actual Cuban property that was already in the United States, Cuban governmental property that was already in the United States, that doesn't mean that there isn't some power to having a federal judgment that says, look, Cuba is actually, people are trafficking in this expropriated property. There should be treble damages. This is something that people should be held accountable for. We haven't forgotten this. These are U.S. nationals whose property was wrongly expropriated. We want there to be something done about it, and we want there to be the poison pill that my colleague talked about earlier that would deter others from cooperating with the
So
Cuban
they
government.
expected private parties to affect public policy for them
Justice Jackson?
with nothing in return?
I'm just trying to puzzle through where you landed with Justice Kavanaugh, that Congress wanted to go back to the pre-FSIA world in this particular context, such that the president was controlling when these suits go forward and when they don't. I guess I don't understand why that doesn't put the onus on Congress even more so to be clear about its intentions in doing that in light of our clear statement rule. I mean, that's a huge thing. That's not just we want these individual suits to go forward. I hear you saying, no, what they were really trying to accomplish here was to repudiate in this particular circumstance the reason why the FSIA was put into place, which was to prevent this ad hoc president deciding when and when not to let these suits to go forward. So if Congress was really doing that, why wouldn't they have said it? Wouldn't we expect that they had to have said it in order to satisfy our clear statement rule?
I think that what Congress did is essentially exactly what they did in the Beatty case that Justice Sotomayor was reading from before, which is to say the default rule here is no sovereign immunity in this context. We are adding a waiver, an abrogation of sovereign immunity for these specific circumstances.
Okay, but first of all, they didn't say that. They didn't. Those words aren't in the statute. But that's what you're. Yes, I appreciate. I just want to be clear. They didn't say that.
That's what I
You're
expected
implying
at the
that they
beginning
did that from saying we want these claims to go forward, right?
Yes, and then I'm saying that the waiver power on the back end is something that provides a couple of different functions. One is that it ensures that these aren't something that's actually going to slow down a transition to democracy in Cuba, make it counterproductive. And two, it makes it possible for the president to put back in this narrow category of cases the protections of sovereign immunity that for 6 months at a time. I mean, he can only suspend the ability to bring new lawsuits. He can't actually just cancel out lawsuits.
I understand, but we don't need
Once
to put
the lawsuit is filed, this is not the same as the pre-1962
I understand, but we don't need to put it back in if the FSIA is doing its work to begin with on the front end, and that's the question in this case. So it's just a little odd, I think, I think that a lot of these arguments are really just trying to get around the fact that what the U.S. government did in this Title III action is pretty extraordinary in general, and we would have expected that if they were creating a cause of action like this, they would have addressed the sovereign immunity question. And in the absence of any statement about sovereign immunity, the question is, did they intend for the FSIA to be operating, or did they intend that by not talking about sovereign immunity, we would read this statute to necessarily mean that sovereign immunity is abrogated? And it seems to me the second is more implausible. I know what Ms. Ratner said, but it seems to me that the kind of natural way of looking at this is that when Congress was silent in Title III about abrogation of sovereign immunity against the backdrop of a statute that governs how you abrogate sovereign immunity, that it was intending to allow that statute to operate. And if it wasn't, we would have expected them to say that.
Well, we have several different provisions that are like pulling individual provisions out of the FSIA and incorporating them here. They're doing all that. We know that Congress was legislating against the FSIA. We know the executive branch had raised concerns about going beyond the FSIA. I think that the suspension power is a way to ameliorate those concerns, those international law concerns, and I think that what it indicates is that Congress understood that this was indeed strong medicine. The poison pill that my colleague referred to earlier today is strong medicine, and if it is so strong that it might kill the patient, the president should be able to use his ability to evaluate foreign policy and what's going to happen in Cuba in order to decide we're going to pull back a little on it for 6 months at a time.
Thank you.
Thank you, counsel. Mr. LaBelle?
All right.
Mr. Chief Justice, and may it please the Court,
This guy's a
Section 1604 of the
professor.
Foreign Sovereign Immunities
University of
Act
Pittsburgh or something
provides
like that.
that foreign state instrumentalities shall be immune in U.S. courts unless one of the exceptions in 1605 to 1607 are met. Nothing
Regular
in
immunity.
Title III's text abrogates that immunity. Title III's cause of action is not inconsistent with that restrictive, non-absolute immunity. Congress considered whether to create another exception to immunity and decided not to when the executive objected. This court should not read in an exception where Congress did not enact one. Rather, the court must harmonize the two statutes if there is any way possible to do so. And here it is obvious that it's possible. Title III allows lawsuits against foreign instrumentalities where one of the FSIA's exceptions are met. Petitioner therefore pivots to a practical argument that because of the embargo's heavy restrictions on trade with Cuba, few Title III suits could succeed. That policy argument can't substitute for the absence of an explicit textual abrogation or an irreconcilable conflict between the two statutes. But moreover, petitioner's factual premise is just wrong. Helms-Burton gave the president the power to ease the embargo, and there are now 70 general licenses that have resulted in $8 billion of exports from the United States, billions of dollars in remittances, and millions of travelers flowing to Cuba in the last 2 decades. Finally, petitioner concedes that under Title III's text, if there is abrogation for Cuban entities, there is abrogation for all the instrumentalities of all countries that trade with Cuba. I welcome the court's questions.
Could you give an example of an action, a Title III action that could be brought consistent with an exception under FSIA?
Sure. There are now 50 Cuban importers that import millions of dollars of goods from the United States, grains, chickens, all sorts of goods, under general licenses. They enter into a contract with an American exporter. The American exporter ships the goods. The Cuban importer pays the money to the exporter. That is a direct effect. All of those Cuban importers could be sued if they're using expropriated property. The ports, the docks, as we heard this morning, the airports, the warehouses, their offices, all of those are likely to be on expropriated property. That's one. Second, the case you heard this morning. when the cruise ships went into to the docks in Havana, there were 6 Cuban instrumentalities that either owned or operated those docks. Havana Docks could have sued any one of those. And there are innumerable cases. But the key point is that Helms-Burton gave the president the power to expand or contract the embargo. And various presidents have used that to either ease the embargo or expand it. And you cannot fix in time whether or not this was going to happen in 1995, 1996, or now. There has been an enormous expansion of trade with Cuba, and that expansion allows for the possibilities of many suits. But back to Justice Sotomayor's question before, I don't think this court can evaluate how many suits there would be, whether it's too few, whether it's too many, what to do about it if it's too few. That's the job of Congress. This court's job is to evaluate the text and see if there's an irreconcilable conflict. And as I think in their answer...
On that, I'm sorry to interrupt, but you keep mentioning irreconcilable conflict. And I think Ms. Ratner might respond, well, my duty is to show a clear abrogation of sovereign immunity, not that there's some way to reconcile these two statutes. That only comes in when we get to implied repeals under our case law, Carcieri versus Salazar. And we're not dealing with, she would say, an implied repeal here. We're dealing with an express repeal. And she has evidence, and you may find that insufficient or adequate, but and we can have that argument. But I think what she would resist your suggestion that she has to show a super clear abrogation, not only show that Congress abrogated sovereign immunity, but that it also made clear its intention to displace the FSIA. Thoughts?
Well, there are 2 statutes. So they have to make clear, you have to reconcile the 2 statutes.
Well, not necessarily. Carcieri says you have to reconcile them when one's an implied repeal. And
Right.
Again, I think her argument would be, I'm not arguing about, well, she would say that too, of course, because she wouldn't give up anything. Fair enough. But I think she'd say, my primary argument is that there's an express repeal. And so, yes, in other circumstances, you go to the FSIA. But here, why couldn't Congress, for example, I mean, I think we've talked about it in Title III, if it had said we abrogate sovereign immunity, nobody would be talking about trying to reconcile that with the FSIA, right? We just
Correct.
wouldn't be doing that. We would be taking the statute on its own terms. And she's saying that's essentially what happened here. Now, you may disagree with that, but this reconciling of things really is kind of a sideshow, isn't it?
You're right that I disagree with it. There is undisputably no express repeal.
Oh, fair enough.
Undisputably.
But you'd agree with me, though, that if it were an express repeal,
If there were an
we wouldn't
express
be talking
repeal,
about reconciling things.
Correct.
Okay.
Correct. If
All
there
right.
was, and what Kurt said about an express repeal is if the statute said in so many words that it was stripping sovereign immunity.
And that's the real question before us, isn't it?
But that's not here.
Okay. No, I understand that point.
If that's the real question, we win undeniably.
Well,
there is no express appeal that anybody could read.
I think
in
it
this
would
statute.
probably be deniable by Ms. Ratner, at least.
Okay, yes, I'll agree with that.
And by the U.S. government, it
And
turns
maybe
out,
the
too.
U.S. government.
Yeah, so,
But hopefully none of
well,
the
right,
justices.
exactly. Let's talk about that, though. And I understand the toggling on and off switch by the president can cut both ways. But one way in which it could cut against you potentially is, why would Congress have put that in there except for if it thought that the FSIA didn't apply, and it was kind of reverting to the old world in which courts would ask the State Department whether or not a suit should proceed as a matter of comedy and grace?
One, it's not, they didn't put it in there because they thought the FSIA applied. This statute, Title III, violated international law, extended U.S. jurisdiction in many controversial ways. And the president Secretary of State Warren Christopher, it said the statute in general, Title III in general, should not be enacted because of the very cases that you saw, the very case you saw this morning. But again, they could sue if the Foreign Sovereign Immunities Act doesn't apply. They can sue Russian airlines. They can sue Chinese airlines. They could sue Qatari airlines. They could sue any.
Mr. Lobel, if I might redirect you to the question.
Okay, I'm sorry.
Yeah. Why would Congress have put that toggle switch in, giving the president the opportunity to turn on and off liability, if it weren't concerned that there would be Charming Betsy, international law, possible concerns? And it was essentially saying, isn't it kind of an acknowledgement we're not doing the FSIA, we're kind of doing the old regime, the ancient regime, where the State Department tells us whether or not a suit should proceed?
Two responses. One is they were worried about private suits going on, suits against not instrumentalities, but private parties all around the world.
I take that point.
And that's why they wanted the president to have the right not to suspend the FSIA, but to suspend the cause of action generally. They didn't say you can suspend the cause of action against foreign instrumentalities, or they said you can suspend the cause of action because the cause of action itself was very controversial. And second, they didn't want the president to toggle on and off on immunity. They just said the president can suspend the cause of action, but they didn't say anything about whether the president could override immunity.
The effect is the same. I mean, looking at the structure of the statute, to pick up on Justice Gorsuch's questions, the president has a huge role in this statute. So that's looking at the text, and then you look at the real world of what's happened since the enactment of this statute. And the president's been front and center every 6 months for 23 years, right? And that effect was those suits couldn't go forward. And the question I think I have looking at that and looking at the real world is similar to Justice Gorsuch's, but it seems like it would be odd to put the president front and center and then on top of that the FSIA, as opposed to the whole idea was Charming Betsy, international law, Cuba. The president is the person in our constitutional structure who can weigh all that as to Cuba, and the president's going to have the power, and that's how it's operated, and we don't go through this FSIA alternative that Congress had previously enacted. So that's one way to look at it.
The president textually is given the power to suspend the cause of action. The text says nothing about the president's power to suspend immunity. Now, of course,
well, what's the difference between those two things?
The difference is
in practice.
In practice is that you can not suspend the cause of action. You could suspend the cause of action, nobody can be sued.
Right.
If you don't
including private parties.
Including private
so
parties.
So this is a suspension that doesn't just have to do with foreign sovereigns.
Exactly.
This suspension goes way wider than that.
Correct.
So it's not clear that the suspension has anything to do with FSIA rules.
I don't think it did. It had to do with the fact that the cause of action itself was very controversial.
And the amount of resources against which attachment could occur is vastly greater against private entities, right?
Correct. That's why the private entities
because more of them,
sued.
including other foreign governments, have more property in the U.S., correct?
No question about that. But
so the suspension, given what Justice Alito pointed out to, which is there's going to be very little assets of Cuban agency or the Cuban government in the U.S. Most of the assets are going to be in the private lawsuits.
Correct. But back to Justice Gorsuch's question, because I think it's central.
Well, before you do that, I don't want to interrupt the chain of questioning, but I thought you told me, at least, well, you didn't tell me, but I thought you told us that the receipt by a U.S. importer of money from a Cuban instrumentality would fall within the commercial activity exception of the FSIA.
Correct, by a U.S. exporter of goods to Cuba, and they would receive money back in the United States.
Yeah, okay, but then you just, 2 minutes ago, 1 minute ago, you said there would be very little property here to be executed on.
Oh, no, if it was against a Cuban entity. Against a Cuban entity, they couldn't execute, but it would fall within the FSIA's commercial exception because it would be clearly a direct effect. But back to Justice Kavanaugh. the text gives the president the power to suspend the cause of action against anybody, private entities, cruise lines, Cuban entities, or any third country's entities. It does not give the president.
So it's even broader. I mean,
Yeah. But it does not give the president the power to suspend immunity or to override immunity. What the president could do is say no suits can be brought. The president does not have the power to say that once suits are brought, and if they are brought against a foreign government entity, I'm suspending the FSIA.
That's a fair point. I just think it's structurally trying to figure out how this fits together is why I'm asking these questions.
But that's the way to harm. The provision allows for the suspension of the cause of action, but doesn't give the president any power whatsoever about an immunity except to prevent these causes of action.
And the point I was making with the SG is that if the Congress's intention was to give the president a toggle switch with respect to sovereign immunity, wouldn't we have expected to see that in the statute? Because that's like an extraordinary thing.
Exactly, Your Honor. And as Justice Jackson alludes to, Congress made a considered, comprehensive determination that we didn't want the president to be doing this because it led to all sorts of bad things. I mean,
that was the point of the FSIA to begin with.
Yeah.
Right?
Why do you think the presidential provision's in there?
Because,
given the FSIA.
Because Title III itself was incredibly controversial. And the president argued not just that the Foreign Sovereign Immunities exception should not be in, but Title III shouldn't be in. And actually, Warren Christopher, the Secretary of State, sent a letter to the House on September 20th excoriating Title III. It's bad for this reason, it's bad for that reason. He didn't mention one reason, foreign sovereign immunity, and that's because they knew they took out the exception.
Well, maybe that's also because, the Cuba and its instrumentalities were the most culpable. I mean, so you're going to go after the private entities because that's where the money is, but maybe Congress and the executive weren't as concerned about the sovereign immunity question when they were talking about Cuba.
Right, but the question isn't Cuba's culpability, as the argument has shown. What Congress was interested in was deterring trade and transactions with Cuba. And if you look at the findings, 6081, 5, 6, 7, 11, it's all about deterring third countries from entering into joint ventures, entering into trade with Cuba. And so that's what, but I don't think in any event you
because it didn't want Cuba to continue to profiteer and make money off of the property that it had expropriated.
Correct.
Yeah.
But that says nothing about sovereign immunity.
Yeah, I mean, I'm not fighting with you about that point. I'm just saying that I don't think this whole reliance on the Christopher statement to the House does that much for you. But anyway.
Well, no, I used the Christopher statement only to rebut the argument that Congress still must have thought, or that the president still thought, that there was an abrogation of immunity. The fact that Christopher never mentioned that 3 months later after they took out the exception meant that the president no longer thought there was an abrogation of immunity and therefore didn't argue against it at that point.
Just to be clear where we stand, you've made some statements during your argument that seem to me to suggest that you think that the mere fact that Congress did not say expressly that it was abrogating sovereign immunity is sufficient. That's the end of it. We don't need to look any further than that. Is that your argument?
No.
Okay. So then the question is what we can infer from what we see in the statute, right?
I don't think so.
In the relevant context.
No, I don't think it's what you can infer. I think there's two ways that you've said in Kurtz and FOMB that you can abrogate immunity and that you can abrogate the FSIA. Either some express language, which you don't have, or providing a cause of action against the government entities, in this case would be foreign government entities, which would be rendered a dead letter, which would be rendered meaningless.
Well, that's an interesting reading of Kurtz, but there's nothing in the opinion that talks to that.
Well, certainly there's something in FOMB, which Kurtz relies on, which says
Kurtz itself doesn't say anything about that.
It says negate. And I think that reading Kurtz in any other way would both be inconsistent with your precedent and would leave this court in all of those situations down a path of determining what's not a dead letter. Is it like in the expropriation exception? Is it that there are 1% of claims that can succeed? How are you going to determine that?
Well, if we knew that Congress thought that the immunity conferred by the Foreign Sovereign Immunities Act would wipe out 99.999% of the potential claims that could be asserted under Helms-Burton, wouldn't it be a fair inference that it did not intend to preserve the Foreign Sovereign Immunities immunity?
I think that the text governs because you can't determine whether it would knock out 99.99%.
Well, what's the difference between 100 and 99.9 or whatever? In the case of 100, you're inferring. They wouldn't have created a cause of action against a foreign government instrumentality if it was a dead letter. It's an inference, and I don't understand why the inference stops the minute you can find 1 in a million claims that might get through.
Even if I agreed with you that you can make that inference, that's not the case here.
Well,
there
first
are
of all,
many
do
claims
you agree with Justice Alito?
I do not.
So we can only make that inference if 100% of cases are
If you
eliminated.
look at the statute and you look at the FSIA and you look at Title III.
No. Forget about the FSIA. We've dealt with that.
Mm-hmm.
We're just dealing with what's required to abrogate sovereign immunity. And you're saying, okay, you can either use the magic words or you can create a cause of action that would completely be useless otherwise.
Correct.
0% of cases.
That's right.
You agree with those two things?
I do.
But once we get to 99.9% of cases, you say that same inference is unavailable.
Because I think it's impossible to tell, looking at the statutes, how many, not in this case, but more generally, whether or not, how many cases are too few, whether or not they're going to succeed. If you could say, we know for certain that 99.9% of all the cases are going to fail, maybe then.
All right.
But you'll never know for certain.
Okay, so now we're at 99.
Right.
Okay. How about 90?
That's exactly my point.
The slope slips.
But you conceded 99?
No, that's why I didn't concede 99.
Well, you didn't at first.
I said maybe.
Oh, maybe. Oh, maybe. Okay, all right.
But the reason that I don't want to concede 99 is because then you say, what about 90%? And the answer to that is the answer that Justice Scalia gave in the NMO case. If you think that too many cases are being excluded, go to Congress. Get Congress to enact a new statute.
Well, then
Don't amend this statute.
Then we're magic words, right?
No. I can give you an example where the FSIA, Congress could provide a cause of action without explicitly abrogating the FSIA, and it should be abrogated under Kurtz. Let's say there was a spate of automobile accidents in some country or some region in the world where all the instrumentalities, all the automobile accidents were caused by foreign instrumentalities. And Congress enacted a statute. There was some ether going around in the Congress, and they forgot that the FSIA existed, which clearly isn't here. They were staring the FSIA in the face. But let's say they said there'll be a cause of action for any American national injured in an automobile accident that occurs in another country. That would be barred by 1605, that would be barred by the FSIA's tort exception, because it requires that the tort occur in the United States.
Mr. Lobel, isn't the real reason why we have to keep the Kurtz avenue narrow is because if you don't do that, you end up end-running Congress's intentions with respect to enacting the FSIA? That we have a statute that Congress, as Justice Kagan said at the beginning, thought about the universe of claims that could be brought against foreign governments, said we don't want this being done in an ad hoc fashion anymore, so we're going to create a statute that lays out what we, the court, has said subsequently is the exclusive way in which you get to sue a foreign government. Kurtz comes along, and we see this kind of one circumstance in which we might conceive of an exception to application of the statute that Congress has created for this purpose. And it is this dead letter, if you have a cause of action, but there's no way you could ever, abrogate sovereign immunity or a cause of action against a government, but you could never recover. Then you go, okay, that really does have to be interpreted as a situation in which Congress did intend for sovereign immunity to be abrogated, notwithstanding the FSIA. But if you get broader than that, if we're in 99% of the cases, 97%, 97%, then you could have a rule operating outside of the FSIA to do the very thing that Congress didn't want the FSIA or didn't want to have happen, which is why it enacted the FSIA. So this exception has to be like really tiny, or else we don't give effect to Congress's expressed intent to have the FSIA be the exclusive avenue for abrogating sovereign immunity.
Exactly, Your Honor. Exactly.
Well, the FSIA may have been the exclusive avenue when the FSIA was enacted, but the Congress that enacted the FSIA does not have the right to control what later Congresses do.
Correct.
So I
And
don't
that's
know
why
where that- I
that's
don't-
Justice Gorsuch's point, right? Later Congresses can say with respect to each statute, this don't apply the FSIA here, and they can say
But they
that.
didn't.
But what's happening here is that we are now implying that later Congresses intended that. With that language doesn't appear in this statute, but we're having a 2-hour argument as to whether or not we should interpret it. And I don't understand that.
Right. And it's not any
Come on,
magic
textualists.
words. They just need to.
I think Justice Alito had a question.
Oh, sure.
That's all right. Go ahead.
Okay.
Well, just one last point.
Oh, you were about to make a point. Yeah, you forgot what you were saying, didn't you?
They claim that you can harmonize the statute,
What?
the two statutes, by reading a tiny exception into the FSIA. And I agree with Justice Jackson that once you start reading that tiny exception in, it will expand. Camel's nose will be under the tent. But that does not harmonize these two statutes. The rule that's specific
Yeah, Congress is the legislators.
can override a general. In this context, doesn't apply when there's an implied repeal question. Their reading of the statute is that you have a narrow exception, a narrow
ready for food,
repeal
too, as soon as this-
of the FSIA, and that's still an implied repeal. As this court said in Home Builders, it doesn't matter whether you call it an exception, an amendment, an implied amendment, it's still an implied repeal. And it contradicts the FSIA. The FSIA 1604, section 1604 says, foreign states shall be immune unless one of the exceptions apply. They want to read the statute exactly how, Justice Alito, you didn't allow them to read the statute in Home Builders. Just add another exception. Just add another criteria, which is not in the statute.
In 1996, were there instrumentalities of the Cuban government that were engaging in commercial activity in the United States?
There definitely were. You don't have to take my word for it. The Undersecretary of State, Peter Tarnoff, testified before the Senate committee dealing with this exact statute, the Helms-Burton Act, and said, in many respects, the trade with Cuba is substantial. And he was right. There was $65 million of medicines and medical supplies, not just humanitarian goods. Medicines, medical supplies. There were
Alito is
over
totally going to do that
20,000
to you.
travelers in 1993, 50,000 travelers in 1994. And there were $250 million, according to
We're getting crosstalk
Exxon's
now between these. I love it.
testimony, exhibits in the district court, of remittances going to Cuban entities in 1994. And as the Court of Appeals held here, those remittances could be the basis of lawsuits under Title III. And I don't think you can fix it to 1995, 1996 in any event, because the statute gives the president the power to expand trade with Cuba. And so whatever the case was in 1995, given that Congress gave the president the power to expand trade, they must have anticipated that trade might be expanded. In fact, in Section 112 of the statute,
Why
it
did he occasionally
explicitly,
drops these?
anticipates that the remittance policy will be expanded.
Thank you, Counsel. Justice Thomas, anything further?
Just so I'm clear, pre-FSIA, could Title III work as it's written?
Pre-FSIA?
Yeah.
It could, because pre-FSIA 1952 to 1976, it could, because there was a restrictive regime of immunity, which wouldn't have rendered Title III suits meaningless. Prior to 1952, it probably wouldn't. It probably meets the Kurtz acceptance.
So this is basically a statutory case.
It is clearly a statutory case. You've got to interpret these two statutes harmoniously.
Justice Alito?
That's important.
Justice Sotomayor?
Under Kurtz's language, you either have an express waiver but
Bye, Crispus.
a implied waiver of sovereign immunity that is, quote, unmistakably clear in the language of the statute. And then what Kurtz says when there's a cause of action against a government on a claim, it has to be clear enough to effectively, quote, negate a claim Congress has clearly authorized, correct?
Mm-hmm.
You're relying on the negation question.
Correct.
And my colleague said, well, doesn't the amount of the negation, how much is enough? And the point is, however, you're saying we don't know how much, but there's a meaningful amount, correct?
Correct.
This is not 1%.
It's not 1% in any event. It was a hypothetical question, but here there are hundreds of claims, thousands of claims probably that could be brought.
And if you go as far as petitioner wants, there's hundreds of, maybe thousands of claims against foreign governments and foreign entities, correct?
Yes, the statute says, doesn't say claims against Cuban entities. It says any instrumentality of a foreign state, of a foreign state.
So we could be expanding this even more.
Correct.
Thank you.
You'd be allowing plaintiffs to sue every instrumentality in the world that does any trade with Cuba.
Justice Kagan? Justice Gorsuch? Justice Jackson? Thank you, Counsel.
Thank you.
Rebuttal, Ms. Ratner?
Thank you. 4 points. First, Justice Alito, to your question about why this practically matters. The first is, yes, there are not significant assets of Cuban instrumentalities in the United States. We have the ability to seek those assets worldwide, which is pretty standard fare in dealing with international judgments. The second is that Exxon is a company that plays the long game. We've had this claim for over 60 years now, and so there may be changes in the future that affect what assets we can recover on. Second point, I hate to complicate the presidential suspension authority further, but I do want to be clear that there are 2 suspension authorities that are specific to the Cuban government, to Cuban instrumentalities. That's 6064A and 6082D. So this can't be dismissed as just potentially suspensions relating to private entities' claims. Third point, I think the food and medicine importer examples really underscore the extreme mismatch here of a Congress that shut down commerce and allowed a few humanitarian examples, food imports, family-oriented remittances, medicine imports, and now, under respondents' theory, those are the only hook, those are the only claims that you can bring against Cuban instrumentalities, are the very thing that Congress decided to have a little more solicitude for. I think that creates an incredible mismatch with what they were trying to do here. Finally, I want to underscore we are not asking for this court to have some broad rule that once a sovereign is covered by a cause of action, that's enough. Again, we have pointed to all of these overlapping provisions. This is the express and only defendant called out. There are rules specific to these claims and judgments. There are multiple overlapping suspension authorities, and there are jurisdictional provisions that take this claim out of the FSIA. So that is the sum total, and that is enough for a background statute like the FSIA, just as it would be enough for a background constitutional or common law immunity protection. Thank you.
Thank you, Counsel. The case is...
Okay. All right. I just typed yeah because I was told I was not interacting enough. So, okay. Well, there we go. All right, let me run through a couple of things real fast. Because obviously there was a lot. We're at 3 hours, so I'm not a lot left in my brain. But what I did note, a couple of things. I really was not expecting so much conversation in the first case. I was kind of expecting it to be over pretty quickly. So it went on a lot longer than I expected. One thing that sort of stuck out is that they did talk about ITT. There is, so I hinted at this in my my video this morning and the one I think I made yesterday or Saturday night. As I was researching these videos and trying to get some more background on what was going on here, because part of the problem is I don't know a lot about U.S.-Cuban. I don't know enough, certainly, about U.S.-Cuban policy to explain why they did some of these things. And that was something that was really bothering me. So I wanted to be able to say, this is why they did this is why they did that. And so I went in and did some research to try to figure out some of what was going on. And the problem was, as I'm researching these things specifically, I kept ending up in these kind of conspiracy-adjacent rabbit holes. And one after another. And part of that, I think, is just the nature of the beast. When you start looking into 1960 and the Cuban Revolution, you just kind of start seeing a lot of stuff about, second guy on the grassy knoll and that sort of thing. And so I'm sitting there like, oh, this is interesting. And then I was like, wait, hold on. This is starting to sound a little over the top, like, dial it back. So I switched to a next subject, but then the subjects kept coming up until I got to a point where I was like, okay, are these so crazy? And one of the things that I kept seeing is that the guy who owned Havana Docks is this kind of really controversial figure. And now his grandson and two of his cousins who live in France co-own the majority share in what's left of Havana Docks. The other shareholders include like Warren Buffett and some other people. And apparently this one kid who's like the grandson, his name is Michael Bain, B-E-H-N, I think. But the grandfather was Sostenes Bain and owned ITT, which they talked about a little bit in the case. It's International Telephone and Telegraph, or Telegraph and Telephone, whatever. Basically AT&T except ITT. And he was, there's some questionable stuff, and I can't tell what's true and what's not, so I have no idea. But it did make for some interesting stuff, and I was wondering whether it was going to come up, and it did a little bit, so I was like, woo! We have some interesting stuff happening here. The other thing that was kind of interesting is that the stories that I saw, whether true or not, I have absolutely no idea, are that the grandson and this other guy really sunk a lot of time and effort over the past few years into kind of reviving this case, or bringing this case up, making this this stuff happen. And one of them, so there's the one guy who has this thing related to the docks. The other guy claims to own or have ownership claims over like 80% of the Cuban coastline. Now, when that commission that they talked about that went through and actually evaluated everybody's claims, they only certified, I think if I read this right, like 30% of his claims. So he says a huge number, it might be a lot smaller number, and my guess is if he's under the age of 80, that he probably bought out a bunch of other people's rights and has consolidated them, but that's worth a lot more than this one dock. So my guess is that this is a trial case to see what the court will, if the court will lay out some sort of a test that they can then use on this other case, and that they're kind of co-financing this. That is just a shot in the dark. This whole thing, like, that might all not even be the real story. I cannot tell what was real and what was wackadoodles. I have no idea. And there's enough craziness in this area that it's really hard to tell. But I did think it was at least interesting and worth mentioning because it's probably part of the story. Probably some percentage of it, at least, is rooted in fact, whether the whole thing is or not. The other thing was, I talked about this a little bit. I am really excited about the idea of because I came from a civil law background where, I studied both common law, American common law, and civil law, which is the system that's in place in a lot of places in the world that weren't British colonies. One of those places is any of the French colonies, which is why I studied it in Louisiana. But Cuba also is rooted in the civil law because they were a Spanish colony. And that's actually the original roots of where Louisiana got it too, but that's a whole side thing. So this is rooted in Roman law, and one of the concepts that they have a different system of property, different ideas of property than we do. And so one of the things that you can own as a piece of property, as a theory of property, is something called a usufruct. And to own a usufruct, I can take these out, on a piece of land means I own this square of land, but not to live on, not to do anything on. What I own is if anything is produced by this piece of land, such as, let's say we grow orange and apple trees on it. The oranges and apples are mine. If we get oil out of this land, maybe, that might be mine, or the money from it might be mine. And it's called a usufruct, which means use of the fruit of the land. I get the usufruct from that land. And usufructs are a property interest. It is something that you own. It's as tangible in the mind as anything else you can own within the civil law, and it can be limited. And according to what I understood, it's from France, but originally it's from Rome. That's where it came to. Sorry, I lost it for a second. So what if I understood what was going on? These guys did not own a lease to this dock. What they owned in exchange for building the dock, because that was the quid pro quo, the this for that. We're going to build the dock for you, and in exchange, we get the usufruct, but it's a limited usufruct. We get any money that comes from use of that dock for loading and unloading cargo. And that was my understanding from the report of the expert who read all this stuff, the Cuban law expert who read everything and wrote this report of what they owned in Cuba. And what they had traded wasn't like a regular lease payment for that. It was they built it, and then in exchange, they got to take that money from it. Her read on it was that they didn't get to take the usufruct for people paying to land on it. And so their payment was more limited. But not only the courts, not only the judges, but the lawyers, in my opinion, didn't quite seem to understand the difference between a lease and a usufruct. They mentioned the word a few times, and then nobody seemed to understand what it was. And the only reason that I understand what it is that I spent 3 months studying it. So I am not 100% sure that that's exactly what's going on, but like a quick thing, they tapped a couple things in my brain. I was like, oh, it's a use for it. Yeah, sure, fine. What they did say is that the district court read her report and said, I don't agree, which they're allowed to do. But they also said today that the question of whether or not that court or that report was correct or not was still up in the air. It had not been re-reviewed by the circuit court. So that was still something that could be reviewed later. And Anyway, but I wanted to at least explain what it is because I was really excited about it because I don't really get to hear that word very often. And it's something that I spent a ton of time learning and will basically never use again because I'm never going to be in a place that uses usufructs anymore. So it's a rare occasion I get to explain that. Okay, the second case, the Exxon case, there were a couple of things that I thought was important and interesting. One is that they talked a lot about the lack of usability, which essentially meant would they have set up a whole thing, a whole law that was designed to be able to sue the country of Cuba, knowing that there's no way to get money out of Cuba. There's no way to enforce the judgments. And that seemed to catch a couple of the judges, like, that seems weird. And I kind of agree, and especially if you were going to do that, it does seem like you would have been a little more explicit about it. Like you would have clarified that that's what you meant. If you were going to do something kind of off the reservation like that, you would have clarified that's what you meant. Again, I do think that the purpose now is to get these judgments against the country of Cuba and then seize Cuban assets in Venezuela. Because we don't have access to Cuban assets in the United States, but we do now have access to them in Cuba, or in Venezuela. Then they brought this big thing right here at the end, which I think is what Oregano's saying right here. Yeah, there's a whole rule of statutory interpretation that you can't read any part of a statute to mean nothing. That is like a basic rule. You can never read part of a statute to mean nothing. And it's very important that Justice Thomas stepped in at the end there to make sure that what we were talking about was a purely statutory interpretation question, which has a bunch of ripple effects on how we're going to read this. And I was kind of surprised that he's the one who brought that up because it's probably not going to play in the favor of who he would have wanted to support, but maybe I'm wrong. The other big thing was the question was, so the president had this switch, this on-off switch that turned this whole title of the statute basically on and off. And the argument of Exxon and the government was if he can turn the whole thing on and off, then he should be able to control the inner workings of it too. If he's got this massive amount of control over it, if he can turn the whole thing on and off, then he should have control over the little widgets inside. And there is an interpretational concept there about like, if you have control over the big thing, then you have control over the little thing or something like that. And IEPA, there's a Latin phrase for it, and I can't remember what it is. It's one of the canons of construction. What the counter argument was, which was like, I thought brilliant, is that the president is allowed to turn the statute on. I think, although I wasn't totally sure about this until today, that he can then turn it back off again. But if any lawsuits are filed between that time, he cannot stop those lawsuits. Turning it on and off does not stop the lawsuits that were issued in the middle. So he does not have control over the jurisdiction of those lawsuits that have already been filed in the middle. And that was the argument of Exxon and the government, is that if this was being used incorrectly, the president could stop them. And he can't, because he can stop the whole thing, but he can't stop the ones that have already been going. And a couple of the judges seem to be like, oh, all right. So I thought that was good. That was one of those that was the moment, I think, where I was like, finally, this guy has a really good argument, because otherwise I was like, where is he headed? And generally, I think the big argument that I was expecting this to really turn on is that you would generally expect a power like this to be expressed. This should not be the kind of power that is implied. And usually that's going to be, that is a lot of what IEPA turned on, was the major questions doctrine. And then he tossed in at the end there that the Federal Sovereign Immunities Act was not written until later, and so it did change things. And before the Federal Sovereign Immunities Act, this probably would have been just fine, but afterwards Congress made themselves clear, and so we have to follow what they said. So honestly, I don't know. I was sort of back and forth, and the people who I was expecting to say certain things didn't say what I thought. The U.S. also conceded the point during the argument, before trying to pivot. There were a lot of things where I was like, I'm not hearing what I expected to hear. So, and the clear statement rule, I really was not thrilled with the third lawyer. It's really frustrating when something this important is left to somebody and they seem to sort of drop the ball a little, and it's like there's nobody else there to protect what is a very important thing. So, like, get to work, buddy. But, who knows? Maybe he did a better job than I realized. I don't know. These guys get paid more than I do, so. All right, I am going to go have some lunch. I'm going to get ready for tomorrow. Tomorrow we have, what do we have tomorrow? Regano, do you know what we have tomorrow? I cannot remember what you are case tomorrow. It's not the Pung case. It is, hold on. I'll tell you in a second. It's right here somewhere. Sorry, guys. Oh, right. Tomorrow is the one about Nestle. Yeah, Nestle, which is going to be kind of interesting. It's there's a pipeline that runs through Wisconsin, Michigan, and into Ontario, and Michigan was trying to shut it down. There were two different cases, and one was the Michigan AG, one was the Michigan governor. And the Michigan governor's case was successfully removed to federal court, but then she withdrew it. The Michigan AG's case is the only one still remaining. The oil company tried to get it removed to federal court, but they didn't do it within the 30 days that you have to do it within. And so they tried using information, basically dates from the other case that was closed to get that 30-day window to apply to this other case, sort of. It's much more than that, but it's kind of interesting. They're trying to argue that they still get to use that 30-day window and apply it another way. So we'll talk about that tomorrow. I will have a morning report out on it in the morning. I'm sorry the one today was so long, but these cases were a lot, obviously. So, okay, I will see you all tomorrow, and I hope you enjoyed it, and adios. I think everything went pretty well. Thanks, everybody.